Thank you. Good morning. Recognizing a quorum of commissioners present, I call the February 10th, 2026 meeting of the Cannabis Control Commission to order. This meeting is being held remote pursuant to Chapter 2 of the Acts of 2025 and is being recorded. Commissioners Benedon, Stebbins, Roy, and myself are participating in today's meeting. All votes today will be taken by roll call. We have a full agenda today, and I will generally summarize. We will start with commission discussion and votes. There are 3 items potentially up for commission discussion and votes. 1, the delegation of powers to approve licenses. 2, Assured Testing Laboratories, LLC, stipulated final agreement, open meeting law, and release of executive session minutes policy. We can start. I don't know if anybody would like to, if any commissioners would like to make an opening comment. Again, it's a little bit awkward because we're not in the same room. Commissioner Benedon, do you have anything you'd like to start with today?
Thank you. I will wait until our 2/12 meeting when we are all together.
Great, thanks. Commissioner Roy?
Good morning, Chair, to my colleagues and the staff and everybody listening. We have a lot of serious topics to go over today. Just a brief statement. As we recognize Black History Month, I just want to acknowledge all the folks of color, entrepreneurs, advocates, stakeholders, and communities whose leadership, resilience, and vision continue to shape our cannabis industry in the Commonwealth. So thank you for my time this morning.
Thank you. Commissioner Stebbins?
Thank you, Chair. I'll defer to our meeting on Thursday.
Okay, great. All right, thank you. All right, so I think that what we will do, because we do have some participants here from Assured Testing Labs, we will take this out of order. And, I want to begin by stating that this was not a previously tentatively scheduled meeting. And obviously, every time we schedule a meeting, it is tentative, and the chair reserves the right to finalize meetings as they come. But the reason that we're here and the reason that I have some concern is that we have called a special meeting to take a vote for the first time. This is unprecedented. We have an ITL that signed in the summer of 2025 a final agreement and accepted, some significant penalties as a result of an investigation that was done by our staff. So in the summer of 2025, I was not here, but my fellow commissioners, Stebbins and Roy, were. I'm going to just walk you through a little bit of a timeline because I have some serious concerns that we as a commission have not been properly following the statute. And we've seen over the course of a number of years a pattern of either executive directors, and that is plural, general counsel, that apparently do not strictly follow the enumerated powers in Chapter 10, Section 76. The first I will read to you is that the chair shall have and exercise supervision and control over all the affairs of the commission. I've seen multiple memos finding multiple choice ways to find implied power and assumed power that are not directly established in the statute. That is something going forward we have to see where the clearly enumerated powers are, and we need to stop arguing about the implied powers that allow other behaviors to happen that are not legitimate, not legal. I'll give you a couple of examples. Our former executive director in the fall of 2023 appointed an acting executive director, head of agency. That was found by the controller to be an illegal delegation of authority. Only the commissioners have the authority to hire or fire an executive director or an acting executive director. We also saw clearly in September of 2023 when our then acting general counsel deliberately interfered with my legitimate and timely and approved by the state treasurer's office designation of Commissioner Roy to be the acting chair during my absence, which was later determined by a judge to have been illegal. The staff has not followed motion language to collect prorated fees as initially voted upon in August of 2022, and when that was requested by our former Chief of Investigations and Enforcement, it was discovered that that voted upon policy by the commissioners had not been followed. And now here we are today. We have a final order that, again, this is unprecedented that we are even in this position right now. Voting to amend or not voting to amend, we have had an executive director who amended without the authority of the commissioners, amended this final order without any sort of public process. And so I'm going to walk a little bit through, a timeline as I see this, because again, this was the final order and stipulated agreement was signed by the owner and CEO of Assured on August 11th. This was received and voted upon by the commissioners 3-0 on August 14th, 2025. So obviously, this was considered to be one of the more serious violations of state regulation in the history of the commission. It's one of the largest fines that has ever been issued. And I was having a conversation with one commissioner who said, we could have voted to take away their license, but we didn't do that. We voted to give them the opportunity to make things right. There were going to be serious penalties, but $300,000 is not play money. It's not play money to the company. It's not play money to the commission. It's real, and this is a public asset, and that should be coming into the fund. We don't own it. It's not ours. Even as a commission, not ours. It's the public's money, just like the fees that were not collected were the public's funds. And so we have to take our duty as public servants to act transparently and to act fairly. And this is one of the concerns that I have, is the process that we have followed has not been either transparent or fair, because there are multiple licensees in Massachusetts who are facing significant economic headwinds. We know that the price of cannabis has dropped. We know that the overhead on businesses is significant. We know that even with what President Trump said last month, we still have to deal with 280E. So I'm going to provide a little bit of a timeline. Sometime in October, let's see. No, I'm going to go back. I've got this. So on July 10th, the General Counsel, Kajal Chattopadhyay, sent an email to commissioners directing them to avoid ex-parte communications with Assured, that all communications had to go through the legal and orderly process dealing with the staff, in particular under the able direction of Armand Enos. As I noted, on August 14th, 2025, the commissioners ratified an agreement with a final order. On October 31st, after having attempted to get advice from legal counsel, there was a back and forth between Attorney Ladzinski and Attorney Enforcement Counsel Tim Gooden. On October 31st, based on the recommendation of Attorney Gooden that having an ex parte conversation, and at that point in time, I did not know that the general counsel had already warned commissioners against having these offline conversations with this licensee in regard to changing or manipulating in any way this final order. I declined to take a meeting with Assured's CEO. On November 21st, the CEO of Assured sent an email regarding questions about due process. But again, at that point in time, I was aware that our general counsel had basically told us, and this is the dilemma that we have, and this is what I tried to be extremely careful about, and it's why when we go on our tours and we meet with individual licensees, we have to always remind people, or even in, the case where we hear from whistleblowers. And I know that some of us have heard from whistleblowers, and we have had to be extremely careful about how even when we have serious information about public health and safety issues, we have to be cautious about 30A. However, I tend to think that we need to worry more about public health and safety than 30A accommodations or due process rights for licensees, but that's a conversation for another time. So on November 21st, I received an email that laid out questions about whether or not Assured had appropriately benefited from due process. On December 5th, it is my understanding that Tom Moore, I think he is now the acting CEO, he sent an email to our executive director. December 5th was adequate time for us to have posted an emergency meeting to take a vote regarding the pending December 12th deadline for the payment that was owed, the second payment that was owed by Assured. On December 10th, I received an outreach, a text, a Teams from the executive director at around 2:00 in the afternoon, saying he wanted to get my opinion on something. When I asked what that was, it basically had converted from getting my opinion to telling me that he had made a unilateral decision to undermine the unanimous vote of August 14th, 2025, and he had had ex parte conversations with the representatives at Assured, and he did not alert us in time to have a meeting, an emergency meeting before the December 12th. On December 22nd, Executive Director.
I'd like to correct a couple things that were just stated.
Yeah, I'll finish, and then you can correct, okay? On, let's see, on January 23rd, I believe that was an additional request, and on December 22nd, a thank you note was sent by leadership of Assured, thanking the general counsel and executive director. This is the same general counsel who directed the commissioners who serve as judges to not have ex parte conversations with a licensee regarding a voted upon final order. So the thank you note, let's see if I can get that language here. I don't know if I'm going to be able to do this. I might have trouble. Second, well, I may not have the language, but basically the language was thanking the executive director and general counsel for getting around, and that might not be the language, and I'll let you correct that when I'm done, but thanking the executive director and the general counsel for getting this done without the intervention of the board. And there was another email that also, another request that asked if information about the financial status of the company be kept confidential. And I actually raised a question when we considered this hold on one second, right, here we go. I'm sorry, I'm having some trouble with my computer here, anyway. Commissioner Roy, you just sent a text, but if you want to just read the language of the email.
Chair, you're asking me to read the email into the record?
Yes, please, because I can't access it.
Okay, I'm going to read this email into the record from Tom Moore, sent on Monday, December 22nd, 2025 at 6:57 p.m. to Travis Ahern. Subject, thank you and happy holidays. Executive Director Ahern, a sincere quote, thank you for your support in extending our payment. I logged in for the meeting, a marathon session, and appreciate you and the GC's effort to secure our payment extension. The commissioners were not necessarily going to make it easy for you, as is their job. And your positive support was greatly appreciated by both myself and the staff here at ATL. My hope for the coming new year is that we can put the events of the past year behind us and move forward together in a more open, cooperative way. It's occurred to me that as much as our industry relies on each of us knowing the intricacies of a constantly evolving marketplace, we spend little time sharing insight that we collect from our sectors of the market. I hope moving forward we can change that. My door is open and I'd love the opportunity to sit down to discuss how we can help advance this industry, provide perspectives on the testing space and changes that can help grow the market. Happy holidays to you and the CCC staff. I hope you are able to spend time with your family and friends. Cheers to a new year. Thank you, assured Tom Moore, CEO.
And
Madam Chair, can we also read the response? Because the response
wh-
is the most relevant part of what we're discussing here.
when I'm done. Okay. All right, go ahead. If you'd like to read the response to the email, go ahead. But again, it's
Okay.
still
So
part of it. It's I'm fine, but I'm laying out information, and I will give you an opportunity to explain why you had ex-party communications.
okay, so
and
ex
why you
parte
ins-
is also not being utilized correctly in this case, but we
Okay,
can
all right.
discuss that as well. But
Well, again, I'm just
record,
quoting your. I apologize. I'm just quoting your general counsel who used that term. If the
Right,
general
and
counsel
it is
provided us
applied
with the
differently
appropriate
to a
term,
commissioner
okay.
versus the executive director. But just with in the context of what Commissioner Roy just read, I'd like to read my response to him.
Okay, and I'm going to point out, and I will point out that when you are acting as executive director and not inserting yourself in the role of a commissioner, which you have done, then you must be held to the same standards as the commissioners are. So again, why
I'm
don't
happy
you
to have that
provide your answer?
discussion. Do you
Yeah.
mind if I read the response?
No, go
to
ahead.
the
That's
email that
fine.
Commissioner Roy
That's
read?
fine.
So
That's
that was
fine.
received by the executive director directly from Tom Moore on December 22nd. My response on December 29th was, thanks, Tom. Happy holidays and New Year to you as well. Please note that, as was communicated to your counsel, if you're going to request an extension of the original third payment due date, which I'd like to discuss in a minute, you need to do so in writing through enforcement counsel so I can coordinate with the chair for an agenda item. The other note on potentially meeting, I said, please go through my executive assistant. So the response was reiterating what I will talk about when you allow me to speak about the actual timeline here, which was I'm directing him to say anything beyond the third payment, which was a minor adjustment that I will go through as well. You need to go through EC to get this for an agenda item.
Okay, and again, you
Madam Chair?
received, go ahead, Commissioner Roy. Yep, go ahead.
My question through you to the executive director, a comment, that is an appropriate response, but why wasn't that response given for the second payment when there was time, when you got it on end of business on a Friday and we had till the 12th? Why wasn't that response given in
Because
regard?
the
That's an
timeline-
appropriate no, we had
Absolutely.
time.
The
We had
timeline
time.
that was laid out before missed the actual date after the 5th. So the timeline before is not a fully accurate timeline, which I also need to correct, as well as the comments about ex parte when I'm given the opportunity to do so. I'm happy to do that now if you'd like, Madam Chair.
Wait a minute. Go ahead, Commissioner Roy.
If I may. So last evening I had emailed you and you said that you received it at the end of business on December 5th, which I looked at the calendar in December. That was a Friday, which would have afforded us time on Monday or Tuesday or Wednesday, would have afforded us an emergent, we could have called an emergency meeting. That's an appropriate response. I just don't know why you didn't give it for the second payment.
Okay, the discussion did not happen on December 5th. I got an email at the end of the day on December 5th, and the call with Assured happened on December 9th. I reached out to set up a
Commissioner
meeting with the
Roy,
chair for December 10th.
Commissioner, okay, all right, okay, go ahead.
Uh,
Go ahead,
that's
finish,
uns-
finish, let the
okay.
executive, I'll let the executive director finish. Go
Okay,
ahead.
I mean, I'm happy to go through the whole calendar here, but I think some of it overlies with the original timeline that was laid out. Would you like me to go through the calendar, the
No,
timeline?
I think Commissioner Roy, I mean, again, this letter was received before COB on December.
It was not a
5th.
letter. It was an email asking for a meeting. The meeting was set up and the call ended up happening on the 9th, which is not the point about the amount of time between the 5th and the agenda setting for the 12th. If I had had the full request on the 5th, I see the point, but that is not the actual timeline. The 5th was asking for a call, which happened on the 9th. I reached out to the chair on the 10th, and the timeline from there basically is all laid out in what we have
Yes,
here.
Commissioner Roy,
I'd like to read that email that you received
Please.
on the 5th.
please. Please. You'd like him to read the email or you're going to read it?
Or you could read it into the record, so my colleagues are afforded this opportunity to hear it.
Yeah, Executive Director, could you read that email exchange in full? And your response on the, I'm assuming on the 5th?
Let me see if I can find it. All right. I reached out to you via phone. This is from December 5th at 3 p.m., 3:06 p.m. Tom Moore to Travis. I reached out to you via phone a couple weeks ago. However, I've not heard back from you. I'm hoping that we can meet with you before Thursday of next.
Could you just stop? So they reached out to you by phone weeks before the 5th. Is that what that email says?
I believe there was a missed call on November 20th. Please let me know if you can schedule some time to meet with us. I understand there's a critical time right now for the CCC. However, it is an extremely critical time for us as well. I urge you to allow us the opportunity to have a dialogue as soon as possible. In the interest of full disclosure, I did have a brief opportunity to talk with Commissioners O'Brien and Roy following our ITL meeting where you and I met and exchanged business cards. That was the ITL meeting on site in Worcester. The commissioners were not willing to engage in a discussion in person, but did ask me to put my concerns in writing. Below is my email to them. I believe it frames ATL's challenges in moving forward without help from the CCC. Neither commissioner responded to the CNL properly as directed by the GC earlier. We need your help. Can we talk? My response was, I believe next Wednesday may be the only way to achieve your request of a call prior to Thursday. I've asked the executive assistant who will reach out Monday to try to schedule a time.
Okay. So when he attempted to call you prior to that email, did he leave a message about what he wanted to talk about?
I believe the voicemail was asking for a call and did not provide any details.
Mm-hmm. So on the 5th, you knew what he wanted to talk about.
Not from anything that I had other than I was aware of the stipulated agreement as you all were. And again, the information that was presented and the
So you
decision
don't
that
think
was
that
made.
you don't think that might have been appropriate to give me a call to say, hey, I mean, because obviously you knew this deadline was looming, right? Had you done anything to work with the staff to ensure that again, these are public funds, not our funds, not your funds, not my funds. They're public funds that are coming in. And this is also, one of the concerns that I have about delay when we have businesses that are operating on the edge that may have potential fines that are hanging over their head like a sort of Damocles. However, if they go out of business, maybe they don't have to pay. And there are some other current examples where we have taken a long time to finalize investigations and enforcement of licensees that are facing receivership or potential closure. So to me, every bit of delay means that the public is potentially deprived of resources that come into the fund that pay for important programs. So again, this is what I consider potential, I don't know if it's willful, but if that were me, if I were the executive director, if I was well aware of this, one of the single largest fines that has ever been levied against a licensee, knowing that your general counsel has told people not to have ex-parte conversations, this is not a ministerial, and I hope someone has their dictionary or their blue,
If I may, Madam Chair,
yeah,
I'm happy to
please.
get into the decision-making as well, and I understand your perspective.
No, Commissioner
Certainly
Wright,
within our,
Commissioner Wright.
Yeah, so I just want to read into the record because legal will ask me for this email anyway. It's not marked privileged or confidential, so we've referred to it numerous times. So I'm just going to read the email into the record from our general counsel. It's titled Assured SSO Communication from Licensee from our general counsel, Kadra Chatapahe, and to CC Travis Ahern, Michael Baker, and commissioners were BCC'd. It was sent on July 10th of 2025 at 2:24 p.m. Commissioners, it has been brought to my attention that you were each sent an email this morning at 10:02 a.m. from Assured Testing Laboratories in connection with a summary suspension order, SSO, that you were informed about today at public meeting. In keeping with the discussion at today's public meeting, and in order to adhere to your obligations under General Law, Chapter 30A, as potential adjudicators in this matter, I would like to instruct you not to open any attachments or reply to that or any communications from the licensee. These are considered ex parte communications and may be used as a basis to challenge your impartiality in the matter. As the executive director stated at today's public meeting, all the information shared with you today at PM was publicly available. Going forward, I ask that you avoid discussing matters relating to the SSO or interacting with the parties about this matter and engaging with others who might have an interest in the outcome of this matter. Should you have any questions about this or wish to discuss my instruction further, please do not hesitate to reach out to me. Best, Kajal.
Okay, thank you, Commissioner Wright. Now I'm going to, and again, we've received a memo from our general counsel, but I'm told that it's privileged, so I will not refer to that today. But I have, I'd like to read into the record a memo that is not listed as confidential, and I'm gonna talk about what delegation is, what is ministerial versus a decision. So a delegation from the commission to the executive director potentially can violate due process requirements under General Law Chapter 30A. It can also violate longstanding precedent on what can be delegated, and it also can potentially violate open meeting law. The violation of due process requirements. The executive director is the administrative head of the commission responsible for administering and enforcing the law, not adjudicating enforcement actions. General Law, Chapter 76, subsection J, the commission shall appoint an executive director. The executive director shall serve at the pleasure of the commission, shall receive such salary as may be determined by the commission, and shall devote full time and attention to the duties of the office. The executive director shall be a person with skill and experience in management, shall be the executive and administrative head of the commission, shall be responsible for administering and enforcing the law relative to the commission and each administrative unit thereof. Our Administrative Procedure Act prohibits the executive director from being involved in the impartial adjudication of matters. Our Investigations and Enforcement Division investigates, prosecutes, and enforces. Our Chief of Investigation and Enforcement is a direct report to the executive director. The commission deliberates and adjudicates, including voting as impartial adjudicators on settlement stipulations that enforcement enters into with licensees. For purposes of due process, our Administrative Procedure Act mandates a separation between the enforcement function and the adjudicatory function. Therefore, our executive director cannot be involved in the adjudication of enforcement actions. This is a violation of longstanding precedent on delegation. There is no express delegation in the statute, and courts have strongly held against implied delegation of matters involving judgment and discretion. The Supreme Judicial Court has consistently adopted a strong position against such implied delegation. For instance, I referenced Commonwealth versus Maletsky, 203, Mass. 241, 246, 89 Northeast 245, 247, dated 1909, and there are others. I know that in the summer of 2023, when current judge, former general counsel for State Treasurer Goldberg, and then not acting, but interim chair Sarah Kim questioned how the commissioners can delegate authority, and then general counsel, and this is inconsistent with the opinions that we're receiving now. Then general counsel Christine Bailey basically questioned the authority about delegation and subdelegation, and she offered as backup to her position a reference to a treatise written by attorney Jerry McDonough, who happens to be my former general counsel when I was state treasurer. And I will make sure that all commissioners have a copy of this, but it basically states that when there is discretion and judgment involved, that discretion and judgment cannot be delegated to administrative staff. So where implied subdelegation involves the exercise of discretion by the subordinate official, the subdelegation is invalid, essentially applying fundamental concepts derived from the law of agency, prohibiting an agent from further delegating personal duties involving the exercise of a high measure of discretion, skill, and judgment without the consent and approval of its principal. The court has developed and applied a distinction between the subdelegation of discretionary and ministerial duties or acts, where the implied subdelegation involves the exercise of discretion by the subordinate official. The subdelegation is invalid. Where, however, the implied subdelegation involves the performance of purely ministerial duties or acts by the subordinate official, the subdelegation will prevail and will be permitted to stand. In the leading case of Brown versus Newburyport, the Newburyport City Council adopted an order authorizing and directing the city treasurer, with the approval of its finance committee, to borrow from time to time in anticipation of taxes. The Supreme Judicial Court found that subdelegation to be more than a ministerial act and improper. The court, in construing the order of the City Council, reasoned as follows. The crucial word to be construed is approval. It is used here by a municipal legislative body in a formal order to express a supervisory power reposed in one of its subcommittees as a restraint upon the action of an executive officer of the city, which might serve the purpose of enlightening his judgment, controlling his discretion, and limiting his opportunity for folly or dishonesty. I like that. It occurs in a vote relating to the borrowing of money for municipal purposes. This is no simple matter, but involves a high degree of skill in order to determine the time and conditions under which the most favorable rates of interest and discount may be secured in the light of the actual financial necessities of the city. Approval in this connection means that the members of the Finance Committee, acting upon their official responsibilities and having in view the public welfare, shall investigate and sanction according to their own independent judgment each separate borrowing made under the order. It implies reflection and sound business discretion as to each loan proposed. It did not confer a mere ministerial function, but imposed active and important precedential obligations. Official duties involving the exercise of discretion and judgment for the public weal cannot be delegated. They can only be performed in person. So the definition of ministerial.
Not sure if you can't see me or if you're just not calling on me, but I did have my hand raised.
Yeah, no, I can't. You have your it's fine. Thank you. I'm still going, but thank you. When you keep your camera off, it's impossible to see you.
My
but
camera
anyway,
is on, Madam
okay,
Chair.
thank
I just
you.
would
I'm
like
still
to clarify for
reclaiming,
the record if I
reclaiming my time. Reclaiming my time. You have not been recognized. You've not been recognized. You've
There's
not been
no
recognized.
time to reclaim here, Chair. You haven't assigned time.
Okay, I have not
allotments
recognized
for-
you. I have not recognized you. You are not recognized.
My hand is raised. I do wish to speak.
Good. You're not recognized, but thank you. Okay, Violation of open meeting law. Open meeting law requires that matters to be handled under the commission's authority be deliberated with a quorum in public meeting for purposes of transparency. Under General Law, Chapter 10, Section 76E, 3 commissioners shall constitute a quorum, and the affirmative vote of 3 commissioners shall be required for an action of the commission. General Law 38, meetings of a public body to be open to the public, notice of meeting, except as provided in Section 21, all meetings of a public body shall be open to the public. The executive director's amendment of a stipulated enforcement agreement outside of open meeting defeats transparency and invokes preferential treatment for a licensee who is found in violation of laws and regulations. Now, I will state that the conversation that I did have after with the executive director, this is not, and we just had an issue where through a great deal of work on the part of our legal team, special props to Erica Bruno and Mike Baker, we found out that there was a ministerial error, that there were commas and some sort of a form that should have been included in regulations that we sent to the Secretary of State's office. They were not included. In voting on those regulations, we allowed staff to make amendments to ministerial, but this is not judgment. When the executive director said to me, I had to make a decision about whether Assured could make its payroll before Christmas or they would make a timely payment. That is not a ministerial decision. That is not checking a box. That is weighing, that is judging, that is usurping the authority of the commissioners. It's not checking a box. It's not, this was a serious penalty that was voted upon unanimously by the commissioners. So I have asked for a description of minor. This is not minor. This is major. This is a unilateral change to one of the largest. It is unprecedented that an executive director intervenes and interferes with the final and serious vote. And in the conversation that I've had, with one of the commissioners, we could have taken their license away, but we didn't do that. But this was meant to be serious. This was not meant to be easy. And so that is why when you told me what you were considering, you were weighing not laying off people. You were weighing before Christmas. You were weighing.
Madam Chair, can I explain my own logic and not have you explain my logic?
Your logic doesn't matter. It's almost not
my
your
logic is speaking to the ministerial nature of what happened. Please go ahead. Please. Okay. So the question again is not reducing the amount that the commissioners agreed to, and it is not changing the period of time in which those payments are made. The only change that was allowed, which was documented, was reported to the public meeting in the following day and is put up online, was that the second payment due date was moved to the third payment due date. And as explained earlier in my response in writing to Assured, but had already been provided to them and I had provided to you, was I am not comfortable changing any dollar amount or the period of time when those 3 payments were due, which was a decision that was made originally on the stipulated agreement that was presented to you to allow for cash flow of the business, to allow them to pay a substantial fine over a period of time, but by an end date that would be not close to and bumping up against a renewal date based on past experience of the commission, which the EC can give you additional clarity on if you'd like. But ultimately, just to be clear, there was no change to one of the largest fee amounts. There was no change to the time in which those payments were due. It was moving the second payment to the third payment due date. And that is what I am defining, and I'm happy to get into further, why I don't believe that required re-adjudication.
Commissioner Roy.
To the executive director through the chair, did that decision that you made not to adjust the amount, but the fee structure, did that involve your discretion or judgment in any capacity?
My deliberation on the issue was about keeping it within the parameters and not taking away the adjudicatory authority of the board. So
That's not
keeping
my
no change to
question.
the dollar
I'm sorry.
amount, that is
No,
what went
did
into my
it
decision.
require, did you use your discretion and judgment when you made that decision? That's my question. Did you use your discretion and judgment when you made that decision?
As I just explained.
Can
So
I
that's a
ask?
yes? I just want to say, wait, for the record, that's a yes. you
please.
used this- So I just want, yes, you.
As
used
I
your
just
discretion.
explained.
Now, Executive Director, you were the Executive Director when this was voted upon and signed. Why didn't we just require them to pay $300,000 up front?
Again, I believe the discussion at the time and EC can provide more thought on what led to what was put in front of the board, but the $300,000 up front is a substantial amount, and that paying it over time has generally been requested in previous examples. And then the issue that we've run into in the past that was considered and actually discussed when the stipulated agreement was discussed at the board level was to not allow any payments to go past the renewal date.
Is it easier to pay something over time than it is to pay something up front?
It depends on somebody's cash flow.
Okay, so you're not saying that it's, so why was this not just paid up front? Why not just the 300,000? Why, if you're not going to answer, oh, it depends. I mean, that's not a straight answer. Is it easier?
It's a very straight answer. Everybody's cash flow situation is different.
So then why did, so if it's just the same, if it's easy, if it's just, so anyway, so cash flow. So now we're getting into cash flow. So now we're getting into an issue because I think that this is what is hard, what is not hard. So we're saying cash flow. So I actually asked you, I believe at the last meeting, were you confident that this licensee was going to be able to make its final $200,000 payments? And you refused to answer that question. So have you had conversations with Assured about their cash flow?
We've had no additional conversations. What I have is what the board has, which is the written request that is on the agenda today. It does explain some of their cash flow issues.
Have you had, so when you had your offline conversation, you did not talk about cash flow. You did not talk about the pain that was going to cause them having to, did you have a conversation about their ability with cash flow to either pay the fine on time or pay their salary? Did you have that conversation offline?
If you're referring to the December 9th call, that was the request, was that they would need additional time to make both payments and continue to pay their bills.
Right. So you did have a conversation with them, not just that email. So you did have a conversation with them in this phone call about their cash flow. So you were making a judgment as to whether or not this would be easier or harder for them. Is that a fair statement?
And the request was to extend both payments.
You're not answering the question. Is it a fair statement that you listened to their appeal to you directly, not to the commissioners who voted on this final order? They appealed to you. They talked to you about their cash flow. They said, this is too hard for us to do. And you'll put us in a position where we won't be able to make payroll. Did you have that conversation?
That's correct. Yep.
That doesn't sound very ministerial to me. That sounds like a judgment to me.
And again, beyond the third payment due date, the explanation to them, as was read in the record, was that would need to come to the board to potentially amend the stipulated agreement.
But you've already amended the stipulated agreement. You've amended it.
The second date did not go beyond the third date, and that is what is being requested of you today by the licensee who's here to present what they are requesting of you. Have
you amended the terms of the agreement in any way, shape, or form?
The second date was moved.
No. This is excuse me. This is a yes or no answer.
Yes,
Have
the
you
second
amended,
payment
just
was
let me
moved
say
to
it,
the third
have you, I
date.
just want to get this clear. Have you unilaterally made a determination to amend the terms of this final judgment that was unanimously voted upon by the commissioners?
Within the 3 dates that were originally set, yes.
Is that a yes?
The word yes was following the sentence I just said. I'm not sure what you're looking for here. You can disagree with my decision. That's fine. I kept it within the parameters.
You made
I
the
explained,
you made the decision, you made the
leaving the
decision without.
adjudication to the board, which is what you're here to discuss today.
No.
Are you going to
Okay.
discuss that matter or not?
Yes, excuse me.
I'm not going to
Commissioner-
answer the
Commis-
same questions multiple times.
Commissioner Roy.
To the executive director, to the chair, when you modified the payment structure, did you know my intent?
I had the intent of the 3 payments being done by February 10th was what I was working off of.
That's not the question she asked. Go ahead, Commissioner Roy, repeat the question.
When you modified and amended a final order and stipulated agreement ratified by this board 3-0, when you made the modification to the payment structure, which involved judgment and decision-making, did you know my intent?
The only intent I'm aware of is from the discussion of the board in approving the stipulated agreement.
For the,
I
so
cannot know
for the
your
record,
intent personally.
so for the record, that would not have been my intent. But I was not afforded the opportunity to share my intent. And the first call came in
You are
in
being
November,
afforded that opportunity now.
I'm finishing November 20th and to the December 12th is 3 weeks. So the ball was dropped to get the commissioner's intent. The first call came in on November 20th and this board was not asked what our intent is.
The licensee was told to bring the request to the board if they needed to adjust any payment outside of the 3rd date. I understand your point. That's all I can answer on that question.
Okay, so in moving on, so Commissioner Stebbins, can I just ask you to weigh in? When and again, you and Commissioner Roy are the only two who were here when this extremely stringent payment schedule was determined. Can I ask you why? In voting on this, how did you intend this to play out? Did you want this to be very serious? I mean, I'd just love to get your take on when you were asked to vote on it. It was very serious. Were you satisfied that this was a significant enough penalty, but that it provided enough grace and time to deal with, at least as it was signed and stipulated to by the licensee? Were you comfortable that this had the right balance, that you as a judge said, I think that this is tough but fair? What were your thoughts?
Thank you, Chair. Appreciate the question. Obviously, a couple points I've been making. First of all, I think it's been said here, I'm sure it was said back in August when we voted on this, certainly a severe penalty that I think was aligned with the scope of the investigation and what our team found. And certainly, we had the opportunity to, at that point, to either adjust the payment structure, but, we agreed with the payment structure. And it was voted on, as you pointed out, 3-0 on August 14th.
But did you have conversations with the then executive director about the severity of this penalty and that you were satisfied with both the timing requirements and the severity of the penalty? Because I have received criticism that, this was a slap on the wrist, even though it was a significant penalty. Did you share your thoughts that you were comfortable with the way that was structured with the executive director at the time?
I don't recall having a conversation with the executive director. I do obviously recall discussing the stipulated agreement in the public meeting. And again, obviously being in agreement with the recommendation of the $300,000 spread out over 3 payments.
Okay. Commissioner Benedon, do you have any questions or comments that you'd like to share about this process?
I do, yes. Thank you for the opportunity to speak. I, of course, was not on the commission, and you were not here either over the summer. And so I feel that my role now as a commissioner is to not reconsider decisions that have been made in the past, but rather to respect the decision-making of my predecessors. The decision-making of my predecessors back in August was to not revoke the license of this licensee. It was to not put them out of business. That could have been the decision, and that was not the decision. I'm not here to second guess whether that should have been the decision given the severity of the situation. I don't know how I would have voted, but that was the decision. And so the way that I view it is that the decision was to instead implement a substantial penalty, $300,000, which, as has been noted, is one of the largest in our history, and to require the payment of $300,000 in what amounted to about 6 months' time. When I review the stipulated agreement, it's lengthy. It's 14 pages. It has 42 paragraphs of facts of record. It has 7 paragraphs and 19 subparts of stipulated findings. It has 26 paragraphs plus subparts devoted to the stipulated remedy. And what was changed was one subpart to adjust the timing of the middle payment. It did not change the fact that this licensee was going to be allowed to continue in operation. Again, a decision, I don't know if I would have made the decision, but it was made. And it did not change the decision, which again, I don't know if I would have made, but the decision was to require $300,000 to be paid in about 6 months' time. And so my perspective is that decisions were made by commissioners in August, and that where we sit today is still very much in alignment with the decisions of my predecessors, whose judgment I greatly respect, and I think the executive director does as well.
Okay, and can I just ask, so one of the questions that I have posed here now is whether or not this was a ministerial act by the executive director versus a judgment. And this is a very, very important point to make. Do you see this as being requiring, because he said, he talked to us about, I weighed the payroll, I did, and I think we acknowledge that the longer it takes to pay, the less severe the penalty. So in essence, by allowing these payments to take longer, we're softening the blow. Would you agree with that, Commissioner Benedon?
I think it's important to me that the total amount of time for payment was not changed. The $300,000 was still due by February 10th, in about the 6 months that the commissioners contemplated. I would view this very differently if the agreement was to make the second payment due on the third payment date and then further extend the third payment date. That's not what was done here in December. And so, to me, that is significant that it was changing the date of the middle payment, but not the date of the total payment. I also want to note that the delegation that was given to the executive director was the authority to make minor changes. And so it wasn't, ministerial. It wasn't about exercising discretion. The word used was minor. And I don't know what the definition is of minor versus major. And I think that is possibly a judgment call to me for the reasons I just said, namely that there was no change to the prior judgment of allowing this licensee to continue in business and allowing them to pay $300,000 over 6 months and not changing that. To me, the change is minor, but I understand that that is a judgment call, and I respect the different opinion of others who view that as not minor.
Commissioner Stebbins, can I ask you, why did we just give them 6 months to pay? Why did we have these installments? If it was,
I
as
mean,
Commissioner
go ahead.
Benedon says, no, we just have to get it in within 6 months. Why was a strict payment schedule put in place? Do you know?
For me, I'll tell you my opinion, you know, the strict payment schedule is for us to, you know, in the payment schedule is just one of the many conditions that were required of this licensee to continue to maintain compliance. And I'll be interested in asking whether all those other conditions have been met. But it was to, again, create a timeline, space out the payments, understanding the intent to allow this licensee to continue to operate. And again, as Commissioner Benedon pointed out, the decision we could have made at that time was to simply revoke their license. But to, you know, put in place, if they are to continue to operate and continue to make these payments kind of along the same schedule, you know, again, I think we all recognize and appreciate the $300,000 is significant, and to follow the recommendations in the stipulated agreement of spacing those out over 6 months.
Commissioner Roy, you had your hand up.
I do. The executive director put, happy to state for the record, if given an opportunity, I made a minor change pursuant to a valid delegation on 9/20/20. And so my understanding of the 9/10/20 delegation to the executive director was solely for the purpose of petitioning a court in receivership or other judicial proceeding. The approval motion states, quote, executive director shall have the authority to petition the court for receivership and other judicial proceedings if there is an immediate threat or danger to public health, safety, or welfare. So is that the correct, could you put the delegation language verbatim into the chat so we could look at that?
Certainly. Thank you. If I may, Madam Chair.
Please.
There are a number of items from 9/10/2020. One of them is the one you're referring to, receivership. The other is the authority and discretion to approve minor changes and changes that need to be made on an emergency basis, provided that the commission retain the authority over changes it would decide in the norm or in the ordinary course. That is also the delegation I read when I updated the record on December 11th when notifying under the ED report. And that is also from September 10th, September 10th, 2020.
Commissioner Roy?
Thank you, Chair. Could you drop that in the chat, Mr. Executive Director, and could you share with us what the emergency was?
The word is, the way it reads is authority and discretion to approve minor changes and changes that need to be made on an emergency basis. So I don't consider it being necessary for both, but ultimately, again, the timeline that I put also in the chat, which I can read, because I know I had to correct some of the timeline earlier. I can go through that whole timeline if you like, but obviously I understand the perspective. If I had returned the call earlier or not taken the call, there might not have been a timeline issue here, but ultimately, by the time I had the call, the agenda for the 12th was set. And so obviously, again, that was part of the discussion and why it was announced under ED report on the 11th.
Commissioner Roy?
I have thank you, Mr. Executive Director. I have a couple of points. So I have some consternation around the fact that as you are a quasi adjudicator, as an executive director, you issued the summary suspension order. You are functioning within an adjudicatory framework, and to have ex parte communications, I believe the same level of 30A needs to apply to you as it does to us. You issued the summary suspension order, so I want that on the record. That and as far as the process goes, how do we learn from this? And from Commissioner Benedon's point, like, how do we look forward? And so I would say, so we have this repeat again. There was 3 weeks, as you just acknowledged, from that initial phone call, and it wasn't brought before the board. And, you know, one can argue ministerial versus minor, are they synonymous? And you used your judgment and you didn't honor my will or intent when you did use your judgment. So I'm going to propose motion language to my colleagues so we never have to cross this bridge again. And hopefully we don't. So I'm just going to share this motion language, and this will help us have a better process moving forward. Hopefully my colleagues agree, so we don't have a repeat of this ever again, and the will of the board will be honored at all times. That was a final order and stipulated agreement. It was ratified unanimously 3-0. In the amended stipulated agreement doesn't have that same language. There doesn't say ratified by the board. So I don't want to ever find myself in this position again. I hope none of us do. So I'm hoping motion language could help us give us all good direction moving forward. Thank you.
Do you want us to entertain that motion now, Commissioner Roy, or do you want to,
Well, I can read it, and if we'd like to discuss it,
Yeah,
you know, as a group, but I see Mr. Executive Director has his hand up too.
Oh, please, Mr. Executive Director.
Thank you, Madam Chair. I would note on the comment about quasi ex parte, I believe was the quote, that we should probably hear from General Counsel on some of those items.
Okay. Yeah.
In terms of, you know, again, I think Commissioner Benedon's point on minor, again, I'm not asking folks to necessarily agree. I understand the position that you've been put in. And ultimately, you know, again, what I intended here was to make sure that any substantive changes to the the stipulated agreement came back to the board, which was, I felt, communicated very clearly to the licensee in terms of discussions and those types of things. Obviously, the executive director has to play a certain role in various cases and works with the board. I understand, again, the timeline here, but I just want to correct as well so that nobody picks up the quote about 3 weeks between a call. There was a call that I took on my phone that came to my phone that was not listened to, picked up or returned. And there was not a discussion until December 9th. So I just want to make sure that timeline is clear.
Was there a message left?
There appears to be a message left. I can go take a look at it, but it did not get into detail, if I recall.
So I will recognize the General Counsel, but for only one narrow question, Commissioner Roy, and then I'd like him to go ahead, Commissioner Roy.
Yeah, it's my understanding that Massachusetts administrative law recognizes that ex parte contacts between an adjudicatory agency and one side in a pending case are improper in adjudicatory review settings. That's Madeira versus Secretary of EOCD. Noted allegations of improper ex parte communications between an agency and a housing authority during agency review. CCC-owned summary suspension framework anticipates a formal record leading to a final decision subject to judicial review, which is exactly what ex parte limitations become critical. So in other words, if this ends up in a court of law and you had these offline communications, does that jeopardize, expose our final order and stipulated agreement because it was amended? Will this, you know, pass the smell test and stand up in a court of law because you had these side conversations, even though you were the one that issued the summary suspension order?
Mr. Executive Director?
I would just kind of go back to the idea on the ex parte discussions about the General Counsel being the appropriate person on this question, but it's up to the chair.
Yeah, the only question I would like, because I asked this at the last meeting and it still has not been answered. This is not the definition, and with all due respect to Commissioner Benedon, it's not minor versus major. It is ministerial. Commissioner Roy, do you have a definition of what ministerial is? Because this is exactly, and this is what we as commissioners, we took a vote on regulations. We granted staff the ability to make certain ministerial changes. Like, for instance, if there was a mistake made, apparently, you know, in the transcription with the Secretary of State's office in the publication, and apparently some chart or table that we had voted on had been omitted, right? Like dotting the I's, crossing the T's, a chart was omitted. But if language was changed and someone on the staff decided, maybe we want there to be a 7-year exclusivity period, and not a 3-year exclusivity period, because maybe the staff person said, I really, and there were some people on the staff who made this argument, that 3 years is not enough to grant exclusivity. So that is something that requires judgment. But ministerial is, oops, we missed a chart. And when I see what the commissioners clearly voted on, not just pay it all, they decided not to pay it up front because that would have been unduly burdensome. They decided not to make it within 6 months. By the way, you know, Commissioner Roy Stebbins, you were there. You could have said, you have six months, get it in however you want it. That probably would have been the most flexible. But there was a reason and there was a judgment implied in the parsing out, the timing. And so this is not a ministerial. So I'm asking our general counsel, because I don't think that the term minor, that was referenced in a non-controlling delegation that does not apply here. So Commissioner Roy, can you describe or share what the definition of ministerial is that I think is appropriate here? And again, it will color, and I think, you know, require, I mean, again, I pointed back to one of my original usurpation of power. The former executive director thought it was fine for him to appoint an acting executive director. And then we had to undo a bunch of paperwork because the controller's office says, that's not what the statute says. There is no clear language within our statute allowing for this delegation. And so we only can delegate ministerial issues. So Commissioner Ray, do you have?
Generally, yes, a ministerial edit is a clerical correction without substantive changes. A substantive edit involves a significant change to the content, meaning, or structure of a document rather than just minor technical corrections.
Okay, and I'm just going to ask again, you know, for debate. Commissioner Benedon, I'm going to ask you, because I didn't really get a straight answer from the executive director, and with all due respect, I mean, do you think that it's easier or harder to pay the money up? Do you think that there is any benefit to the licensee to take more time in paying it? I mean, this is, you know, ultimately this timing was determined by the commission. It was determined, not to put them out of business. We all agree that. It was determined not to require $300,000 up front. It was determined, these are all judgment issues. It was determined, we're not going to say you got 6 months and then we're going to be coming after you in the spring. We made a determination, the commissioners, not you and me, but the commissioners made a determination. And so that's where this is not a minor, this was a thoughtful judgment that the commissioners made. We don't want to put them out of business. We're not asking for a gigundo payment up front. We're not going to give them 6 months, but we made a conscious decision to have it in 3 tranches. And so this is where, I mean, I would love to get your thought, because I don't think that the term minor, it was raised in a non-controlling opinion. The same general counsel who wrote that opinion has basically referenced Attorney McDonough's treatise about the inability of commissioners to subdelegate decision and authority. So I don't know where, I'm curious where you're thinking this is minor, because I don't think minor is the definition here. I think it's administrative. Do you think that if the commission made a judgment not to put them out of business, not to require $300,000 first up, not to give them 6 months, do you think that this is not a thoughtful decision made by the commissioners? Do you think they didn't think about that? I mean, again, we weren't there. I wasn't there.
I think that the minor comes from the 9-10-20 language, the authority and the discretion to approve minor changes. So some authority and some discretion has been granted. This seems to be a use of authority and discretion to approve minor changes, recognizing that there's disagreement about whether this was minor. I certainly think, and again, I wasn't there in August, so I can't speak exactly to what the intention was beyond what is in the four corners of the stipulated agreement. The intention seemed to be clearly to not put this licensee out of business and to give them a total of 6 months to make a series of payments totaling $300,000. And to me, the change that was made is consistent with the judgment that was exercised by commissioners in August. I certainly am not going to sit here now, having not been here in August, and speak to whether this was consistent with or inconsistent with the intention of those commissioners who ably made that decision in August.
So, but that's the whole point, is that there was a rationale and a thought about laying out the payment. So I'll ask Commissioner Roy. I mean, so we shouldn't be, just as Commissioner Benedon says, she doesn't want to substitute her judgment for the commissioners who voted on this. You know, I don't know what thought did you have? Because and what I didn't hear is you have X number of months to pay the whole 300,000. That's not what the clear language of the stipulated agreement says. Doesn't say you have up to. See, that's how we're treating this. That they have up to X number, however many days, to make these $100,000 payments. It doesn't say you have the whole. If they wanted to say you have till the end and you get it in as needed, that language I think would have been included. So when I hear your interpretation, you know, with all due respect, Commissioner Benedon, it's not just a total 300,000. There was very specific language included that talked about timing. So Commissioner Roy, you had your hand up.
Yeah, I have grave concerns about the process. And so this, I feel like my judgment was substituted in this process. And for that, language dropped in the chat, authority and discretion to approve minor changes and changes that need to be made on an emergency basis, provided the commission retain authority over the changes. So do we retain authority over those changes?
Well,
do we retain authority over that amendment made?
We don't retain authority. That's water under the bridge. We lost that authority. That was taken away from us. We didn't retain authority here. And could I have further context? Because it just says authority and discretion to approve minor changes to what? Like what? Where is the heading? Where is the context? To what? Executive Director, do you know?
I can certainly pull up more video from that particular meeting when that was approved. As has been discussed, it's on a list of a variety of delegations. I just want to, if I may, Madam Chair, also add in here as well to the intent of the stipulated agreement. Obviously, $300,000 is a significant amount. That's obviously the majority of our discussion here today. But the actual stipulated agreement and the majority of the discussion of the board at the time was a relatively large package as it relates to dealing with what was put forward in the summary suspension order. And the result of the stipulated agreement also included a suspension of the CEO. It involves hiring a third party.
Yeah, but we're not talking about. We're not talking about that. So that's nice to know, but it's not critical to the conversation that we're having right now. Commissioner Roy.
What is highly critical to this conversation is I'm looking at the list of delegations, authority delegated, and I don't see this on that list. So I don't see it. Were commissioners given where it's written? Where is this in writing for us to see this? Because other than dropped in a chat, because I don't know changes made to what? Where is we need further context. I don't have further context.
Okay. All right. So anyway, I think that we can, I think I have already noticed that we will have delegation of powers, that will bleed into the next meeting, because obviously this was an emergency meeting that we called specifically to respond to the request of this licensee. And Commissioner Roy, I'm
I'm sorry.
Go ahead.
So, and I just want to just add, I know we're going to wrap this up as, we need to move on. We have other business to tend to today, but, obviously the goal is not to put someone out of business. This is not what this conversation should be about. This is about a delegation that was possibly violations of open meeting law, Administrative Procedures Act regarding enforcement versus adjudication roles, and precedent of what it can and cannot be delegated. So my goal here is on process, and let's not have to revisit this scenario anymore. For whatever reason, a call came in, it wasn't received, 3 weeks went, the timeline. So I just want to focus on process and how can we make this better, and then figure out what our next steps are with this final order and move on to the remaining business of the day. So again,
I'd just like to state
process.
that I disagree with all 3 points that the commissioner made.
You're not.
Okay.
What?
I would just like to state that I disagree with the open meeting law item, the ex parte, all of those items. I'm not having an issue with Commissioner Roy's looking to clarify moving forward, but I disagree.
But again,
with those
you
points that were made.
will get a legal opinion that backs you up regardless. Okay, so we understand, the people who report to you will support your legal interpretation, and I understand that. So Commissioner,
Madam Chair,
so
we have
are there,
requested
excuse me,
other
are there
folks to review legal decisions.
excuse me, are there other points that the commissioner, so Commissioner Roy, do you want to move, do you want to read the motion that you have crafted regarding how this was an issue that Commissioner Concepcion raised quite some time ago about delegation. She was aware that we had potentially inappropriately delegated authority. For instance, we delegated authority to the executive director to collect prorated fees, and that was ignored. We need to understand and we need to clarify how and when we delegate and what that is. And we need to clarify, not major and minor, because that is a subjective term. Ministerial has more, I think, heft in terms of legal definition of what is ministerial, what is administrative versus what is a judgment. So unless any of my other commissioners, so I don't know if you want to do that motion now, Commissioner Roy?
Yes.
Would you like to make that
I'll
motion?
read it and then open the floor for discussion around it. That's okay.
Okay, thank you.
Yep. So I put in the chat, I move that the commission direct the executive, or we move that the commission direct the executive director to refrain from engaging in any offline or informal communications with licensees for the purpose of renegotiating, modify, or otherwise altering the terms of any final order and stipulated agreement previously ratified by the commission. Any request for modification or reconsideration of such agreements must be brought back before the full commission for deliberation and vote.
Okay, any questions or comments about that? Commissioner Stebbins?
Thank you, Chair. Thanks for the opportunity to comment on the motion. Thank you, Commissioner Roy. My only concern with considering this motion today is that I'm not quite sure how it falls into our 3 topics on the agenda. And just wondering if we can, because I see this as somewhat a separate discussion from our 3 agenda items, and would urge consideration that we take this motion, the underlying discussion about it and authority, and again, the delegation back on 9/10/2020, and suggest it be added to an agenda either for the meeting on the 12th or another meeting.
Well, is this not in reference to delegation of powers to approve licenses? Is that not, or stipulated? I mean, we're talking about a stipulated agreement, and this naturally flows from the conversation that we're having. I mean, I think this is, you think this is not in scope to have this motion? We can, again, I don't want to have a whole series of meetings on this one particular motion.
Mm-hmm.
Commissioner Benedon, do you have any questions about this motion? Again, this is unprecedented that a final order has ever been unilaterally changed by an executive director in the history of the commission. So I would say that the authority is not there. And I would say that this motion just clarifies that the commissioners retain the authority when they vote on a final order, that order be sound and the intent of commissioners. Maybe we're all going to be gone at some point in time, but this should have motion and it should have value and precedential value. So how do you see this as being outside of the scope if this is exactly what we're talking about here? Commissioner Stubbins.
Oh, I'm sorry. I thought you were asking Commissioner Bennett.
Actually, if I may, Madam Chair,
Commissioner Roy.
then this whole conversation would have been out of scope and we couldn't have had this entire conversation. So therefore, then we violated, this whole conversation was a violation.
Wait a minute, say that again.
Saying the vote is out of scope, but this whole conversation kind of revolves around this motion language, and therefore no one stopped us during this conversation to discuss this, so that our conversation was out of scope that we just had.
Mr. Benedon.
But my perspective on this is that this whole conversation, as well as Commissioner Roy's motion, flowed from our discussion of the stipulated agreement and the changes made to the stipulated agreement. So speaking as one person, not as our legal counsel, I don't have a problem with considering Commissioner Roy's motion. I would be happy to consider that motion. I wish that we hadn't spent the last hour discussing what had happened. I think we can be proactive and look forward and say if we want to consider and define exactly what the authority is or isn't so that we can be clear for the future. I would be happy to do that and very happy to move on.
Thank you. And I
Agreed.
appreciate it. And I appreciate
Agreed.
needing to be forward looking, but there are numerous issues that predate your presence on the commission that we don't get to talk about this. And so this is why we need to make sure, and this is why we need to be transparent. I have received, and I was accused of buckling to public opinion. The only public opinion that I was concerned about was the fact that we have found, and we have been speaking about testing fraud, which jeopardizes public health and safety, which impacts consumers. So the fact that I made a statement that we have been criticized for whether or not this was tough enough, not tough enough, that has happened. But the bottom line is, we had a director of testing who left the position because he was prevented from speaking about testing fraud. We had language that was going to the legislature that was changed that might have spoken about economic incentives for testing fraud. So testing fraud and our ability as commissioners to protect the public health and safety, that's why this discussion is here. And it's why we can't be having offline conversations, because one of the arguments that I heard from the executive director as to why he exercised his judgment was that we had a licensee with a serious financial challenge. Raise your hand. How many of you commissioners have spoken to other licensees who say, I'm dying, we're going to go out of business? A licensee trying to get their provisional license, and they're going to have to pay 1 more month's worth of rent. They're about to go out of business because we have a ministerial check the box that we're holding them accountable to. When I hear the executive director said to me, they are under the gun, financially strapped. This was a conversation I think we had about Boston Bud Factory, that all of our licensees are strapped financially. So if we all have offline conversations, should we be making, oh, sorry, you're not doing well. Okay, we're going to give you special consideration. Oh, stand up in line. How do we help you? So that's why this motion and why this conversation was important, because there are many licensees that are struggling. We've already been exposed by the state auditor for disparate treatment of licensees. That is problematic, and the auditor talked about it. So Commissioner Roy and then Commissioner Benedon. Commissioner Roy. You're muted.
I agree with Commissioner Benedon. We're going to move forward, fix the process. And, so I'm going to request we move the question, but I see Commissioner Benedon had her hand, so I don't want to,
Commissioner okay, Commissioner Benedon, and then we'll move on. Okay, thank you.
Yes, and thank you. And very much along the lines of what Commissioner Roy said, and moving forward, I think part of the real challenge here, and the reason we've had this discussion for the last hour, is that the second payment deadline was extended to require payment of the second and third payments, both on the same date. Today is the deadline. And if the licensee had made the second and third payments as agreed, and that was all that the executive director authorized, we wouldn't be here having that discussion. We knew when we had our last meeting in January that there was going to be, that at that time there was an additional request to extend the third payment. But I feel that what we are frustrated with today is not the extension of the second payment, because if the second payment and the third payment were made, we wouldn't have even discussed it, or we could have discussed this in January. We could have discussed the December action in January. The reason that we are frustrated today is that we as commissioners are now put in the position of being asked to extend the entire payment period beyond the 6 months, beyond February 10th. That's not something that the executive director did. That's what we need to consider today, is whether we are willing to extend that third payment date. That is the far more consequential matter. And so I would be happy to move forward, vote on Commissioner Roy's motion, and then get to the discussion that I think we all thought was the focus today, which is discussing whether we are going to extend the final date. That is a significant consideration.
All right, thank you. Again, I appreciate it, and I understand being forward-looking, but there are, I just think that this conversation was important to have, because remember, this was not a previously scheduled meeting. We had to do this at the last minute. This is a special accommodation because the licensee failed to follow the advice after they were already given one bite of the apple to extend their payments, so without the approval of the commission. And so I do think that it's important to discuss this authority issue because, again, this is unprecedented. This has never happened. And I think that this is inappropriate to happen going forward. So Commissioner Benedon, would you second Commissioner Roy's motion?
I need to read it.
Oh, please. Okay. Yep.
Yes. Okay. Thank you, Chair. Move that the commission direct the executive director to refrain from engaging in any offline or informal communications with licensees for the purpose of renegotiating, modify, or otherwise altering the terms of any final order and stipulated agreement previously ratified by the commission. Any request for modification or reconsideration of such agreements must be brought back before the full commission for deliberation and vote.
Okay.
I will second that motion.
All right, having been moved and seconded, I'll call the roll. Commissioner Benedon?
Aye.
Commissioner Roy?
Aye.
Commissioner Stebbins?
No.
Chair votes aye. It passes 3-1. And now, noting for the record, this is from our general counsel. The chair read from what appears to be two separate documents, and she needs to identify what she was reading from. The first is a legal opinion that I requested Attorney Lodzinski to give me. I am technologically, when we take a break, I will get that put up into the chat. I will share that with my fellow commissioners. And then the other thing that I read from, I think it was an email. Oh, no, I will send you. It was, I think I read a timeline that I had written for myself. So again, just like when you're in a court of law and you're reading from a document, I will get that document to you, but it basically is a timeline note. So I will get that to you again. It was just something that I wrote to myself, just notes. So I will get that in the chat. Commissioner Roy.
Just for clarification, I want to make sure we're all on the same page that today's motion language supersedes the 9/10/2020 motion language, or do we need to rescind that, or do we need to put?
Say
So
that again.
in other words, so the 9/10/2020 motion language that the executive director referred to give him the authority, do we need to, does today's motion language supersede that motion language so we don't have a conflict with different motion languages? Or do we need to some point rescind that one, or do we need publicly say this one is no longer in effect?
Let's put the rescission. I think what we need to do is a deeper dive into any conflicting delegations that may have been inappropriately reasoned. And then we can put this on our, is it February 26th? That's when we have the 12th. We don't have the time to notice for the Commissioner Roy.
So if by chance tomorrow a similar situation comes up prior to our next meeting, does this motion language supersede 9/10/2020?
Just this question, General Counsel Chattopadhyay, would this motion supersede any prior motions delegating authority regarding final judgments? Final.
There would need to be a separate motion that explicitly rescinds the prior delegation. And I do want to add.
Okay, thank you. Executive Director.
I would just say, obviously, the directive from this matter, I think to Commissioner Roy's point, is clear as it relates to stipulated agreements. I think to the point the chair and general counsel just made, if the intent is to not allow latitude for minor changes, emergencies, then you would want to rescind that delegation as we did. I believe it was in October on a previous delegation related to petitions. That was a motion that was made and offering the process that the board was looking for in place of the original delegation.
Mm-hmm.
Thank you.
Okay. All right. So that's been Commissioner Roy.
So until that it's noticed and we discuss rescinding it, I guess I just would love to hear from the executive director. He will honor this motion language and not invoke the other motion language until we're able to address it and appropriately and notice it.
Executive Director.
Certainly, this motion language is clear. I can't think of a scenario for minor or emergency, so I understand the point, and I suppose I'd have to work with the chair to Commissioner Roy's point here if there was an emergency or minor change needed.
Okay. Thank you very much.
All right, thank you. So again, I think that we will get directly to the Assured Testing Laboratories stipulated agreement. I think that we've had a robust conversation. I don't know if anybody wants to have further executive director, if you would like to make any comments about the requested changes that are being asked for here.
Certainly. Thank you, Madam Chair. I would say, obviously, we have the EC, whose team has been interfacing the most with the licensee in terms of making sure through enforcement staff that the stipulated agreements being honored for the variety of other items within there. I would say, we can go through that request, but as was originally requested but not allowed, was it's a 60-day extension on both the second and third payments. As we discussed today, only the second payment was extended 60 days to the third payment due date. So they are requesting now, and obviously they're here as well and can speak if there's questions from the board.
Yeah. And by the way, I don't have any motion language on this.
I do believe there was an intent to answer any questions if there were questions on the request, but the request now essentially would be that the licensee would pay the second payment on the third payment due date, which is today, and then request from you to extend the third payment due date, I believe, by 60 days.
Okay, how about this? I've been asked to take a 5-minute break, so perhaps the general counsel in that break can draft a motion, and then we can come back to this. Commissioner Roy?
This feels special, like a special accommodation once again, quite frankly. And has the board ever assessed penalties and fees or fines for late payments, or I don't know if there's any precedent there. So just
Yeah,
while we go into the break, maybe someone
going
could
to
look
the
at
break,
it.
but I think this is a question that our enforcement counsel can answer. I will entertain a motion. It is 11:54. I will entertain a motion to recess until 12 o'clock. Do I hear that motion, Commissioner Benedon? And I see your lips moving, so I think I
So
saw a
moved.
so move. Commissioner Ray, will you second that?
I'll second that. Thank
Having
you.
been moved and seconded, I'll call the roll. All those in favor, aye. Opposed? We recess until noontime. All right. Back in session, there's been a question also raised.
Chair.
Again, I will, I not
Chair.
only will, oh, sorry,
I'm
can
not
you hear
sure
me?
Commissioner Benedon is back yet.
Oh, sorry. There you are. I will, again, I will need some help putting some stuff into the chat. So I will upload, it's been indicated that the analysis that I received assistance putting together with Attorney Ledzinski does not reflect the Office of the General Counsel. I'll acknowledge that, but I also will be sending out, and I'll figure out how to distribute that, but I'll reference this, an opinion provided by former General Counsel Christine Bailey, which covers similar items that were covered in that memo. So the memo that I read from that references the attorney Jerry McDonough memo, they're pretty closely aligned in terms of the findings. So I will get both of those, but my technological limitations are, I mean, I don't know how to put that into the chat. So I'll figure out how to get that, and I can make that part of the public record later. Commissioner Roy?
Yes, and I understand, you know, the need for general counsel wants to have a disclaimer, but I just want to get assurances that by providing you some legal analysis that there's no punitive measures taken against Attorney Ledzinski, I will be, you know, concerned if that is the case. So I just want to say, just want to make sure that there be nothing punitive actions for providing you legal counsel taken against Attorney Ledzinski. Thank you.
Okay, thanks. All right, moving on. So do we have a, all right, so anyway, we're going to have our enforcement counsel, moving on to enforcement counsel. Frankly, and I want to be clear, I have a hard stop of 1:15. So I want us to get through this, and I would like us to get to launch the conversation about the release of executive session minutes. So do we have enforcement counsel Gooden, is he going to be speaking to us?
Yes, Madam Chair, he's available.
Okay, thank you.
Yes, Madam Chair,
So Attorney Gooden, can you just walk through this?
Yes, of course. So, Madam Chair, are you looking for I want to make sure that I am kind of hitting on the points that you wish to discuss. Here is the request to talk about the request from Shore Testing Labs, or was this referring to, I know there's a question asked before the break as well, which I'm happy to speak to also.
Well, I just basically framing the request. I mean, we don't, I mean, again, this is what happens is I don't have any motion language, so I'm going to have to develop this on the fly. Commissioner Roy, do you have a question?
Yeah, EC Gooding is referring to my question prior to the break about is there any precedent, or does the board have discretion or authority to assess further, you know, late payment penalties or fines in addition to the stipulated agreement as a result for any special accommodation?
Yes, Madam Chair.
Please.
Thank you. So Commissioner Roy, to my knowledge, we have not assessed or collected late fees in any past actions. I know that is something that we are considering as well for any future actions, but those would be built into a stipulated agreement, or if we were going through the 30-day hearing process, we would be requesting that to be a component of any recommended decision or final resolution of the matter. So in short, I'm not aware of any instance in the past where we have collected those late fees, but I do believe it would be within our authority to either build it into a stipulated agreement or seek that as part of any final resolution.
Is that answer to your satisfaction, Commissioner Wright?
Yes.
Okay.
Thank you, Attorney Gooden.
Yeah, Attorney Gooden, I don't even, you have so many letters now in front of your name. I don't even want to try to begin with the acronyms, but what is your AEIOU? What are you?
Madam Chair, so I am still the enforcement counsel However, I believe as noted by the executive director at the last meeting, I'm also serving as the co-interim chief of investigations and enforcement along with Armin Enos as well, Director Enos, excuse me.
Even Travis can't do that acronym justice. So anyway, if you could just sort of set the table for us, you know, and then we can move to approve or not approve.
Absolutely, Madam Chair. So the request before the commission for consideration today from Assured Testing Labs is to, through their counsel, is to consider amending the stipulated agreement by modifying the payment structure set forth in paragraph 65, subparagraph A. They are respectfully requesting that the commission extend the third payment schedule by 60 days. So therefore, the third payment would be postmarked on or before 240 days after the ratification of the initial order. And I believe the board has that email from Attorney Dan Glissman as well. But I can take this language and I can put it in the chat just for ease of reference.
And just reminding you, we were directed by the general counsel not to read that email.
I know there were certain, or excuse me, sorry, Madam Chair, if I may just on to.
Okay, thanks. So if you, can you just get an okay that it's okay to read this to us in public meeting? I'm assuming it is now appropriate.
And Madam Chair, in response to your question there, I believe the request that is before the commission here, I believe is appropriate to share. I would definitely defer to general counsel if I should remove that rather, but I do know that the licensee through counsel also provided some background information, which they requested to not be shared publicly because it does refer to some of their internal operations, but you know, that is at the discretion of the board, I believe, or with respect to any kind of counsel provided by the general counsel here as well. So I would have to defer on those elements.
Okay, Commissioner Roy? You're muted.
Yep, thank you, Madam Chair. To Enforcement Counsel, just for the public listening, on that table, we just walk through, so the first payment of $100,000 was due 60 days after ratification of this order by the commission. Was that received in a timely manner, payment one?
Madam Chair?
Please, thank you. Sorry, I'm just writing down.
Yes, Commissioner Roy, it's my understanding. So these are, I just want to clarify one piece. So according to paragraph 66, payments must be postmarked on or before the dates issued. So I believe it was postmarked on 60 days.
Which made it
the
timely.
60-day period.
Yes,
correct.
Which makes it timely. Thank you. And so in the second payment, $100,000 due 120 days after the ratification of this order was the amendment modification made by the executive director to push it to the third payment date. And so has that been, the second payment been made in a timely manner?
Madam Chair.
Please, thank
If I may
you.
respond to that. Thanks. So Commissioner Roy, I know that our finance team does receive the payments. I'm not aware of a payment being postmarked or sent in at this time. I will note the licensee is here, so they would be able to speak to whether or not that has been actually postmarked or sent at this stage. But it would need to be done today. I'm sorry, Madam Chair.
May we hear from the licensee, Madam Chair, on that?
Please, thank you. Representative of the licensee. Again, we're remote, and so I'm not quite sure who I'm calling on here. Is this?
I believe it would be Attorney Glissman, Madam Chair.
Okay, Attorney Glissman, sorry.
Good afternoon, everyone. Madam Chair, thank you very much for having us this afternoon. For the record, my name is Dan Glissman. I'm an attorney with Prince Lobel Thai here on behalf of Assured Testing Labs. Just to answer the question specifically, a check for this second payment would be postmarked today. It has not yet been sent out to my knowledge, but obviously pending the resolution of today's discussion would impact what amount was to be postmarked as of today, whether it be $100,000 or $200,000, depending on the determination of the commission as on this action.
Okay, so basically, you would have to come up with 200. You would have to make the payment of $200,000 by today. Just to clarify.
That's correct. That's correct. Versus $100,000 today.
Commissioner Stemmons.
Thank you, Chair. Just for clarity, attorney, if I heard you correctly, you would have either $100,000 or $200,000 ready to be payable today.
I would have to defer, quite frankly, to my client as to the availability of the funds for the full $200,000 today. I certainly know that, as we've described in our request, the $100,000 are available today to be postmarked as of today.
Okay, appreciate it. Just clarifying your comment. Appreciate that.
Yeah.
If we don't approve this, will you still send the $100,000 today?
Absolutely.
I mean, if we do approve this, will the $100,000 be? Okay.
Madam Chair, absolutely.
And if we don't approve this, will the $100,000 be coming in today?
Madam Chair, the stipulated agreement as it's amended is very clear that $200,000 is due as of today if no amendment is made. My understanding is my client intends to follow the terms of the stipulated agreement to the best of its ability.
What does that mean? Because do you, I mean, this is also, and this was a question I raised at the last meeting. These are not our funds. These are public funds. You know what I mean? And it's like not, it's not coming into my pocketbook. It's going to the Commonwealth of Massachusetts or the, you know, the marijuana fund. Okay. Do they, and they do have the wherewithal to make that $100,000 payment today. Why didn't they make that payment today? They have till 5 o'clock tonight. Is that what it is? What is the actual deadline? Is it today or is it the 12th? I think it's the 12th, right?
Madam Chair, today is the deadline, and you're correct. The deadline is postmarked as of today. So my understanding and the discussions I've had with the client is that based on the outcome of today's discussion will impact the check that they're writing. So we haven't postmarked it for exactly that reason.
Commissioner Roy.
Could EC Gooden, oh, I see. So could we have the dates? So in other words, I see on behalf of my client, blah, 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 we respectfully request commission extend the third payment by 60 days. The third payment will be postmarked. So 60 days from today? I just want to be clear.
Madam Chair, if I may, I can
Please, thank
respond.
you. I'm sorry, I'm reading and then I'm not looking at your hand. Sorry.
Yeah, of course. So Commissioner Roy, so I just want to back up a little bit just so that we're all speaking on the with the same language here. So in accordance with the stipulated agreement, paragraph 65, subparagraph A sets out that kind of payment schedule. So there were 3 payments of $100,000 due, and that is kind of the benchmark that we're measuring off of is the ratification from the board. So that was August 14th of 2025. So the first payment was due $100,000 was due 60 days or had to be postmarked after the 60 days. That one we have received. So the second and third payment in accordance with the amendment made by the executive director was 180 days. So that is still not on based off of today. It's based off of ratification by the board. So that is still the August 14th, 2025 date. That brings us 180 days following August 14th is February 10th, 2026. So today, the request made by Assured through council is to alter the third payment date from 180 days following ratification to 240 days following ratification. So that would bring us to April 11th, 2026. I will note that is a Saturday. So generally what we would expect is that the payment would have to be postmarked by the following Monday, which would be 4/13 or April 13th, 2026. Obviously, however, this conversation is a deliberation by the board as to accept this request from the licensee through their counsel. I believe, and I would defer to general counsel on this in terms of the actual authority of the board, but I believe if the board wanted to change the specific dates and perhaps not agree to 240 days, but agree to 239 days or some other time period, even just so that we are not going through the weekend, I believe that would be within your authority to consider as well.
Commissioner Roy.
Thank you, Madam Chair. So this licensee has already been afforded an extra 60 days on their second payment, which was due, it was amended on December 11th, due December 12th. So approximately they've already received an extra 60 days.
Right. Yes. And again, this is why, you know, this, and by the way, you know, I'm because this is the clear prerogative of the commissioners, and obviously, have we ever as a commission, never mind the executive director unilaterally doing this, has the commission ever changed the terms of a final order, Attorney Gooden?
Madam Chair, not to my knowledge, I don't believe the commission has ever altered or amended a stipulated
Whatever happened with Boston Bud Factory, where we were not happy with that proposed settlement? Where's that?
Yeah, Madam Chair, so with respect to Boston Bud Factory, that stipulated agreement was considered by the board, or it was brought before the board for consideration for ratification on October 1st, 2025. The board rejected that stipulated agreement during that meeting and directed staff to go back and see if we could renegotiate new terms to that agreement in line with the feedback received by the board. That matter is still under final negotiations with the licensee, but I do expect that would be back before the board in relatively short order.
Define relatively short order, because that's 4 months. That's a 4-month extension. And again, this is why timing counts, you know, because as I mentioned before, we have a number of licensees in receivership. And when there is a fine to be paid, and then a company goes out of business, yeah, the Commonwealth is out of luck, right? I mean, so that's why part of the back and forth talking about timing being minor, it's not minor, it's major. It's major when these companies are financially on the ropes right now, because what it means is that they might delay long enough. And again, this is not what I'm saying that Assure is doing, but delay means a heightened likelihood when a company is on thin ice that we may never get somebody, Bruce, I think, that we may never get those funds, that the Commonwealth and may be denied those funds. So that's my concern. And that's why timing counts. So one of the things, Commissioner, okay, go ahead. Because I had a thought, because I do think this is now the second bite of the apple, and I'm not comfortable with the first bite. I've been very clear, but Commissioner Roy.
So as EC Gooden said, this is unprecedented. This has never been done before. So if Attorney Glissman could share reasons for the appeal for this special request to help us, inform us in our decision, that would be helpful. I'd appreciate it.
Yes, thank you, Madam Chair, through you,
Please, thank
Commissioner
you.
Roy. I'll just take a step back. I would note for the commission that I have been working with the commission since its formation. And so I am very well aware of the unprecedented nature of even our being here today to make this request. The fact that we are here this afternoon, I believe, speaks volumes to the commission's commitment to working with small businesses while at the same time ensuring compliance and safety. And Madam Chair, and through you to the rest of the commissioners, I would like to thank you all for your leadership here and on this issue. And I would also like to thank the staff and the rest of the team who put in a lot of effort on this project and ensuring that Assured continues to operate in compliance and is able to keep their doors open. I personally was there on January 3rd when Assured got its initial order to close its doors. And I sat there in front of a room of employees of 30 folks and had to tell them on July 3rd that they were furloughed for an undetermined amount of time. And I will note from firsthand experience that it was a very real moment. And we then continued to work very diligently with the CCC and your team to bring Assured back to life. And I think what we are requesting here is a reasonable accommodation to allow Assured to continue to live up to its commitments, not only its commitments under the stipulated agreement, which extend beyond just these financial payments, as I think has been noted here. It also includes having an independent auditor that we hope will provide very good information to inform the commission on future rules and regulations as they evolve on testing. It also includes a extended leave of absence for the former CEO, as well as a probationary period and other facets to the stipulated agreement. And so we're hopeful that this request can be seen as a reasonable request to allow Assured to not only stay open, continue to employ its employees, but also live up to its requirements in the stipulated agreement. And I do have the CEO for Assured, Tom Moore, on the line.
Can I tell you, Commissioner Stebbins needs a 5-minute break request, but one of the questions I'd like to ask you directly is the timing of these payments a minor issue or a major issue for this company?
Madam Chair, I don't know, quite frankly. I don't have a very clear picture. I believe it's important that I believe it's critical, quite frankly, for the company to stay afloat, to be permitted this reasonable accommodation.
But I just want you to understand where I'm going with this. This is not a minor issue for your company. If we said not going along with it, the timing of this is central to the impacts on your company. Yes, I mean this is why minor major. I am a little rankled that this has been spoken about as minor, because it's not minor to your company, is it?
Understood, Madam Chair, and you're correct. I believe that they'll have to make some very difficult decisions with their staff and with their team and their operations.
Have C-suite employees, and this is a question that was raised, has C-suite employees been getting paid 100% of their salaries?
I'm unaware of the answer to that question. I do have Tom Moore available here, and he would be welcome to answer that question.
If Tom could, only because I unfortunately I have a hard stop at about 1:15, and I want to have enough time to have the conversation about the open meeting law executive session. So, Commissioner Stebbins, you need a 5-minute break, or I saw you go off camera.
Yeah, Madam Chair, I apologize. If I could have a 5-minute break, my apologies.
Okay, would you like to make that motion? And then if you can, Attorney Glissman, if you can get that answer from your client, and then we can just stick with you about C-suite employees' salaries. That would be great. So why don't you take that 5 minutes? It's 12:27. I'll consider that a motion from Commissioner Stebbins to recess until 12:35. Commissioner Benedon, do I hear a second? I hear
second.
Second. Having been moved in second, call the roll. Everyone votes aye. No one votes no. We are recessing until 12:35. All right, so we're back.
Thank you, Chair.
And I have moved my meeting, so I have more time, but I just want to, just for the record, we, Commissioner, and I think she's coming back, but, we're still a minute, but Commissioner Benedon is raising the issue of the policy because being very, strict adherence to, open meeting law, she, wanted to make sure that she distributed that for us, but that we're actually, not likely going to be voting on that today, but we will just distribute that and have an opportunity, and we will be voting on that in another meeting. I'm correct on that, right, Commissioner Benedon?
Yes, that's correct. And I can distribute it anytime you let me know when we are at that point.
Thank you. All right. All right. Attorney Glissman, have you gotten that answer?
Yes, thank you, Madam Chair. Thank you for the brief moment there. Yeah, I can confirm that there are two C-suite or executive roles at Assured, the CEO and the Director of Sales. The Director of Sales has been at half salary since the company has reopened, and the CEO has been without pay for over the past month.
Okay. Thanks.
And I apologize.
No, that's okay.
I'm
just checking. Go ahead.
I was just going to add to that earlier, Madam Chair, you had asked for some information to serve as a basis for the request here. I'll just make a couple of points here. Being shut down for 3 months, as Assured was, can oftentimes be the death knell for a small business like this. But to their credit, Assured has persevered, and under this new leadership, while today their sales are only a fraction of what they were prior to getting shut down, they're operating at roughly 15% of the sales that they were doing weekly before. They do feel very strongly that their business is improving, that there's a light at the end of the tunnel, that they are seeing an uptick in their customers coming back to them and working with them again. So they feel very positively about the ultimate outcome of the business. And but for those reasons, we respectfully request this 60-day accommodation to allow them to proceed.
But can you just say yes or no? The timing of this payment, is it a minor issue or a major issue for your company?
For Assured, for my client, it is certainly a major issue for Assured.
Okay, thanks. Any Commissioner Stebbins?
Thank you, Chair. If you'll permit me, I have questions both for our enforcement counsel as well as for Assured's legal representative. But if I can start with enforcement counsel.
Please.
2 questions. Obviously, there are other conditions that needed to be met within the stipulated agreement outside of the payment schedule of fees. Has the licensee complied with all of the other stipulations in the agreement?
Madam Chair?
Please, thank you.
Thank you. So Commissioner Stebbins, generally speaking, yes, my understanding is that the licensee has been compliant with all of the terms or additional affirmative relief outlined in the stipulated agreement. For awareness, there was one instance where I believe it was back in September or October, where we did receive a report that the former CEO had perhaps reached out to a client, which would have been a violation. I know our team looked into it. We were unable to substantiate direct contact there, but there was an admonishment provided to the licensee at that time to ensure that that would not happen if it did happen in the future. But to answer your question simply, yes, there has been substantial compliance with all the terms of the stipulated agreement.
Thank you. Commissioner Stebbins, another question?
Sure. And this one's to enforcement counsel, and if permissible, love to ask some questions of legal representation for the company. Enforcement counsel Gooden, if the final payments were made today as scheduled, what kind of what are the key components, in your opinion, of the stipulated agreement, the key requirements of our licensee that effectively go away once the final payment, if the final payment, the $200,000 was made today? What are some of the ongoing monitoring and other recurring costs or recurring exercises of the stipulated agreement that would go away?
Madam Chair?
Please, thank you. I'm sorry, I'm just taking notes and it's hard to do it when you're remote here. Sorry about that.
No problem at all. So Commissioner Stebbins, if all of the payments are received in full, the licensee is still subject to a 2-year probationary period that is identified in paragraph 71 of the stipulated agreement. Additionally, under paragraph 60, or paragraph 67, the suspension of Dr. Pelakoutis, the former CEO, still remains in effect for 12 months. And that began on the date that the respondent appointed an interim or permanent chief executive officer, which was in September. So his suspension will continue through September. There are also additional terms that are identified in paragraph 69 and the subparagraphs contained therein, which identify kind of continued reporting and some additional obligations that the licensee had, although I will note that most of those items were resolved or completed by the licensee prior to the removal of the suspension, but there are some, such as retaining certain test samples in accordance with their revised SOPs that they will continue to do throughout this period. Additionally, with that, there is a bi-weekly reporting requirement contained in paragraph 72. My understanding is that we have been receiving all of those as well. And additionally, there was certain continuing education requirements. And my understanding is all of those have been met as well. So there will be ongoing enhanced reporting requirements and some additional items or obligations that the licensee has that were identified through revised SOPs that were revised in accordance with the stipulated agreement. So in short, there are ongoing obligations beyond the actual payment of this agreed upon financial penalty.
Chair, if I might.
Commissioner Stebbins?
Sure, thank you. Attorney Glissman, a couple of questions for you. If the commission was to approve your request, I guess I'm looking for what assurances would you be able to give this commission, or your employer or your client be able to give this commission that, you know, we're not revisiting this conversation in April?
Madam Chair, through
Yes,
you.
please. Thank you. Yep. Thank you.
Commissioner Stebbins, I have certainly had discussions with my clients on this very topic, and I can assure you that we will not be having this conversation as it gets closer to the final payment. Assured has every intention of making this third payment as requested under the proposed modification to the stipulated agreement.
Someone had raised the question previously, and I'll raise this question with our general counsel. We are not held to the parameters, this is to the general counsel, we are not held to the parameters of what is being proposed or asked for. We literally have the authority to determine what that payment schedule could be. Is that correct, general counsel?
Thank you, Madam Chair. Okay. That is correct. Any modifications to the agreement requested by the licensee at this point are subject to your consideration and approval.
Commissioner Roy, you had your hand raised. Thank you.
Yes, I do, Madam Chair. And so therefore, this board could collectively come up with a different scenario. Let's say 33 1/3% due February 28th, 33 1/3% due March 21st, 33 1/3% due April 11th, and without, also with language saying that no more extensions will be given. So we are allowed to come up with a payment format that provides interval payments as opposed to a lump sum. Is that correct, through the chair to the general counsel?
Yes, that's I was thinking of the splitting the baby, because I think that because I'm seeing this with another current case, that if indeed there is financial hardship in 60 days, Attorney Glissman, I trust your confidence in your client, but this is the second request, assuming that we thought the first one was going to be that's it. And that might be preferable to keeping them on a more regular payment, not wait the 2 months to allow, I think that keeping a tighter leash might be preferable. Commissioner Roy, you had your hand up, and then Commissioner Stebbins, or did you another?
Yes, I
Commissioner
know.
Roy?
Thank you, Madam Chair. Well, to your earlier point, these are monies owed the state. These aren't monies owed to the commissioners. These are monies owed to the state. For violations, for non-compliance, one could argue that could have had significant public health impacts. So we don't take this lightly. As a matter of fact, some of us have been chastised for just doing a slap on the wrist for this. And so giving you yet another 60 days, which would add up to 120 days of extensions. I think where my mind is at is more of interval payments. So the state is in receipt of money that is owed to the state for behaviors that were agreed upon in the stipulated agreement. So I'll just put something in the chat as possible, but I just wanted to share where my mind is at.
While you're doing that, looking at the final order, this order is subject to ratification by the commission. Again, this is a judgment. This is not ministerial. This is not minor. And the terms, all of the terms of this are not minor. They are integral to implementing the will of the commissioners. And it says upon ratification, this order becomes binding on parties. Again, it doesn't say that anyone can intervene. It says this is binding. Failure to comply with the above conditions shall result in administrative action against the respondent up to and including suspension and or revocation of licensure or registration. And so, if the first delay of payment hadn't happened, this could have been a vote of the commission to say, nope, that's it. And so that's where I'm coming from right now. I'm disappointed that this was done in a way. This was not a minor change, it's major. You yourself, Attorney Glissman, have said that this, Glissman, is an extremely important thing for this business to be able to survive. The commission decided they didn't want to close you down. They decided they didn't want to give you, the full 6 months or whatever it was. They made very clear how they wanted that to be. And then that has been upended. And now it's being asked to be upended again a second time. So Commissioner Roy, I'm glad you're better in math than I was. I was the treasurer. I had people who could do this. But this, I would love my fellow commissioners to take a look at this and see if this February 28th, 33%, to this second $100,000, that they make the $100,000 payment today as per the, the amended finding. And then over the course of the next several months, they make these third payments going on. E.C. Gooden?
Thank you, Madam Chair. This isn't, I don't want to, I'm not speaking specifically to what Commissioner Roy is proposing in here, just wanted to also just add for context as well that generally speaking, we also include in our stipulated agreements that payments shall be postmarked on or before the due dates. So by breaking it up this way, I think that's totally reasonable for the board to consider. However, you might also want to, if you're speaking to this specifically, the board may also want to consider saying these are the due dates for kind of the percentages and when we expect those to be due. But if they wanted to pay, say, a lump sum of the whole $100,000, they would be able to do so. So just wanted to throw that out there for consideration.
Yeah, I mean, again, if that I think is something, but again, this is also, we're living in an age, I don't know why we deliver checks or mail them. I'm assuming, most of these things, how are these payments made? Are they made in paper? They are made in paper and they're put in the mail, or are they electronically sent? How do we do that now? EC's good.
Thank you, Madam Chair. So I do not receive these funds personally. Those are sent over or received by our finance department. My understanding, however, is that payments can either be made electronically, or I believe in most instances they have to go through, or excuse me, actually, I believe they are made electronically in most cases. However, there is a lockbox or something to that effect where the commission can receive paper checks that are automatically deposited. So it's a bank lockbox where sometimes those are received. And I do believe that we've just
When
was
can
on,
I ask
Madam
you,
Chair.
when we say lockbox, and I'm not going to quote Al
It's
Gore,
like a-
when we say lockbox, this is not, but I'm saying, do we have a PO box? Do we ever accept paper checks?
The CFAO is
Is-
on if you'd like to.
Oh,
ask the
please,
CFAO.
thank you. No,
Perfect.
CFO?
Yes, thank you, Chair. We have the fines are required to be paid by paper check because our system, our Mass CIP system does not allow for electronic payments for these types of fees. So it is required to be paid by actual paper check. They're mailed to a lockbox. So we have a PO box and at the commission in headquarters, but there's also a lockbox where we direct them to pay, which is directly to our bank. So it's the lockbox owned by the bank, and those payments
Okay.
go there.
And this is at least this is just a knowledge question because I've read some okay. So this is for fines, but like re-upping of license fees, does that have to be done by paper or can that be done electronically?
License fees can be renewed through the system, so they could be paid by debit card, credit card, or electronic payment. And we do give the option for them to pay by paper check.
Okay. And where do these paper checks? We do have a spot within the commission where paper checks come in.
They can be mailed there. So yes, they can be mailed to the commission at headquarters. We would prefer they don't. We prefer they go right to the bank. So we have them mail them directly to the bank. But yes, some people will just see our address and put it on there, and they will come by U.S. Postal Service into the commission. And we do take those as well. We scan them to our bank.
Okay. Okay. Excellent. Okay. Commissioner Stebbins.
Thank you, Chair. Just if I can, a couple more questions for the outside attorney, Attorney Glissman. Attorney, obviously your communications highlight the impact that being under the summary stipulated agreement, has impacted the additional expenses you have carried. You talked about some public relation expenses. Do you know how much your client spent on public relation expenses?
Madam Chair, through you.
Yes, and I know where that question's come from. Yes, go ahead.
Thank you, Commissioner Stebbins. I do not have a specific figure. I know that they historically had not had a public relations staff or consultant on board, but given the nature of the investigation by the commission and the ongoing discussions of Assured over the last 6 months plus, I feel that my understanding is that they felt that they have needed to have available to them a public relations agency available to help support them.
Okay, but
Does that answer
sorry,
your
Chair, if
question? I mean, I understand obviously reputational issues, but also marketing and going to events. I certainly understand that's something maintaining especially after something as impactful as this. One of the things I do want to
Chair,
note.
if I might,
Oh,
I have one more question.
oh,
If I
please.
can.
Okay, sorry, I thought you were done. Okay.
No, that's okay. Attorney, if you, I guess my question is, if you did have the ability to pay the $200,000, isn't that a benefit to your client to get out from under this stipulated agreement and pursue business, kind of going forward without what I'm sure is, concerns among potential customers and clients about still being under the stipulated agreement. Doesn't the value, I guess, hold that if you paid $200,000, the stipulated agreement ends? Obviously, there, as we heard from Enforcement Council, there's some ongoing, monitoring that would be required, but wouldn't it be nice, I guess, for your client to just kind of clear this up, be done with it, and move on?
Attorney Glissman, but that's not what I heard. I heard that they still have ongoing obligations under this agreement.
Understood.
Oh, okay.
Madam Chair, through you.
Please, thank you. Yes, right there. I thought. Please, thank
Commissioner
you.
Stebbins, yes, I know, I can say confidently that my client wishes very much to have all of this behind them and move on into the next chapter of their business operations and continuing to be a successful lab here in Massachusetts. And but I think that they're struggling with, quite frankly, making payroll. And so having a structure, as Commissioner Roy put forth, will just allow them to be able to avoid making difficult decisions on a going forward basis and ensure that they can continue to keep their doors open. And it's expensive to operate a lab, is my understanding.
It's my understanding that they did not acknowledge any of the behaviors that are alleged by our investigations and enforcement team, which included significant potential contamination within products that was not properly reported on. Because testing fraud is and remains something that we are focused on, as an agency. Again, I understand in an agreement like this, you come to an agreement, you don't acknowledge, but you agree, as opposed to, a further, further digging into the processes, and you want to move forward. But this is something that I hope, because it's my understanding that this one licensee, within a very short period of time, captured 25% of the business among, I don't know if it's 13. We know that some testing labs, because they couldn't compete, did go out of business. And so, this is one of the issues that I wanted to raise with, with my colleagues, but also to raise this very clearly with the licensee, that we have statistics. It's why we have a great research department looking at statistics, seeing potential incentives for fraud. And what I have heard from multiple licensees, whether it's people cultivating, manufacturing, also other testing labs, they have said to me and to my fellow commissioners, this is a tough industry and we'll compete. We don't want to compete against cheaters. And ultimately, that's kind of a pretty tough accusation that has been leveled against this company. And, in a very short order, this company cornered 25% of the market out of either 11 or 13. And again, I don't know the competitive landscape over that entire period of time, but making sure that all ITLs understand we're waiting. We had hoped we'd get this by the end of December. We think that this is coming out soon from staff, but we're going to be looking at testing protocols and making improvements to that, because we want to protect the public's health and safety. We also want to protect consumers. When you're not honest about THC levels, and obviously it's science, but it's not as sciencey science. We understand that there are differences among different types of testing protocols. So that's something that we're going to be addressing. But if indeed the accusations that have been lodged against your client, that they were able to garner such a significant percentage of the total market share, that a couple of licensees during this relevant time period did go out of business. The first bite at the apple that you got was a pretty important thing for this company. But if we give you the second bite at the apple, this is something that is a broad industry problem. It's a consumer issue. It's a public health and safety issue. And I want you to know we take this very seriously. As a matter of fact, Commissioner Roy, we've been looking at the issue of inversion. And in New York State, it's not disbar, as some have said, it's debar. We are actually looking at when there are serious risks to public health and safety that we consider debarring licensees in the future, whether that's inverting product, cheating and allowing cheaters to get away with cheating. You know, I want to send that message very, very solidly and very strongly. That's what our job is to do. We need to make sure that we have a thriving industry, but we can't have cheaters. So again, there's no real answer. You know, I'm going to raise this, you know, with my commissioners, how they feel. We've gotten a couple of different iterations. I would like to, unless anybody has further questions, I'd like to sort of move the question if we can, and see what a, you know, how we might do this. Commissioner Roy, I think you came up with the first sort of alternative to what is being proposed here that I actually think is a good idea. But, you know, do you want to make a motion and see if it's seconded, or do you want to talk about what you raised previously, Commissioner Roy?
I put in the chat 2 scenarios that we could contemplate. The first would be 3 payments, providing a 33 1/3 of the 100,000 that's due, being paid postmarked by February 28th, 2026, March 21st, 2026, April 11th, 2026, where the final installment could be made. The second scenario I had proposed is 4 payments of 25% of the 100,000 due. The first being February 28th, postmarked by 2026, 25% of 100,000, 25,000. March 14th, 2026, a $25,000 payment. March 28th, 2026, a $25,000 payment, and April 11th, 2026, a $25,000 payment, which would be the final payment. So those are 2 installment plans, if you will, that I put into the chat for contemplation.
So, any commissioners, I mean, actually, you know, again, I am agnostic as to 33 1/3 or 25%. But again, my concern is that allowing too much time and not having ongoing funds coming in, that if the company, and again, we know that there are significant headwinds facing this company, I don't want to lose any additional. And by the way, we have not charged any interest on this, have we? Has any interest been charged on this, Attorney Gooden? No interest has been charged on this, right?
Madam Chair, no, we have not charged or collected any interest with these fine payments. And just as a general matter too, I'm not aware of any instance where we have collected or charged interest on any fine payments.
No, but you know what I'm saying? This is like free money, right? This has been interest free, and every delay that's worth more to the licensee. So, Commissioner Stebbins, you have a question?
Thank you, Chair. And I think it goes back to some previous discussions we've had about whether we charge for interest, whether we charge, I guess you would call it a late payment. I would like us to have some discussion around that. I'm happy to consider kind of the interval breaking, but thinking of, you know, the notion of an additional $50,000 payment that we could include in that schedule.
I don't know what you mean. What?
Either considering the 33 1/3% kind of payment schedule as Commissioner Roy has outlined, or the 25%, I'm suggesting, should we have a discussion around an additional $50,000 payment, since essentially the terms of the original stipulated agreement haven't been met.
Can I tell you that the terms of the original agreement would have been abided by if we did not have this intervention, okay? If we had actually been able to address this some time ago. So I'm again, I'd like to keep this as simple as possible, get this done. I think that if we're going to be charging interest or charging an additional fine, Commissioner Roy, I mean, I don't know. I don't know what your thoughts are on that, but you know.
I would say back to an earlier point, if we don't make our credit card payments in a timely fashion, we're assessed interest. If we don't pay our property tax in a timely fashion, we're assessed penalties and interest. If the IRS assess penalties and interest. This is quite fortunate for this licensee that at this point, this moment in time, that we don't assess late fees. So they should consider themselves fortunate that, you know, we may evolve to that point, but as of this moment in time, we're not there. What I would be comfortable is saying that this is the final amendment and no more extensions will be granted.
All right, flip a coin. Commissioner Roy, would you like to make a motion? Are there any further questions? Because I think that this splitting might be the smartest thing to do. But again, this no more changes. Commissioner Roy, you raised your hand?
Yeah, I'd like to hear from Commissioner Benedon if she
Oh,
has
please.
any,
Okay, thank you.
yeah,
I didn't,
thoughts or
sorry,
anything.
sorry. Thank you. Commissioner Benedon?
Yes, thank you for the opportunity to speak. I fully support splitting the final payment. I think with the understanding that $100,000 will be postmarked today. That seems to be the understanding, and we are operating on that assumption. For the final $100,000, I would support splitting it into 4 $25,000 payments. Of course, they could pay more sooner, but 4 payments to make sure that the Commonwealth is getting its money. I do strongly agree with all who have raised the point that by extending the payment date, it is essentially providing free money in the sense of not paying any interest. It's an interest-free loan, if you will. And I would support paying or assessing either interest or some kind of additional payment. So for example, instead of owing $100,000 over 4 payments, they would owe $110,000 over 4 payments. I think that is very reasonable for providing a 2-month extension on a $100,000 payment.
Okay. All right. So are there any additional questions or comments by commissioners? And then I might ask Commissioner Roy to maybe make a motion. Commissioner Roy?
So I just want to understand, Commissioner Benedon. So you're suggesting perhaps that we schedule 4 interval payments of 110,000 each to that's an additional only 40,000. So
no.
You're saying I think what she's saying is
so 35. So you take the 25,000, add 10,000 to each payment. So it would be 35,000. Is that what you're saying?
I don't think that's what
no,
she's saying.
I think that would be very steep. I would propose like taking the 25 and making it 27 or something like that for each.
I think what
payment.
you're saying is 10% of 100,000, and you're going to spread that 10% over
right
4 payments. And by the way, that's a pretty good bargain. The 10%.
Can someone do the math, or I'll do it? I just want to see it in the chat.
It would be 4 equal payments of $27,500. And the dates, I believe Commissioner Roy has already put in the chat, but I'll just put the math in there and then I can.
27. You're saying it.
If you're looking to add 10% to the final 100,000.
27,500. I misheard what you said.
Yep. And Madam Chair, Attorney Glissman's hand is up.
Yes. Sorry, Attorney Glissman.
Thank you, Madam Chair. And of course, fully understand and appreciate the intention behind additional interest. I would be remiss if I didn't advocate on behalf of my client. I do believe that a 10% increase over 2 months is a fair, a large increase. Obviously, the maximum interest permitted to be charged by law is 18% per year. So 10% over 2 months is, I believe, excessive to the extent that the commission might consider a modification to the proposed 10%. We would certainly greatly appreciate that.
Somebody do the math on what is not usurious, although I know usury doesn't exist anymore, but no one enforces it anymore. Commissioner Benedon?
Yes, and to be clear, I am my suggestion of 10%. I am not proposing 10% interest. Because I acknowledge that 10% interest for only 2 months would not be $10,000 on $100,000. If it was for a full year, 10% would be $10,000 on 100. What I was suggesting is something like 10% as in addition to the penalty. So rather than a total penalty, a total fine of $300,000, it would be increased to $310,000. I was not intending to pose it as interest, but rather as increasing.
And
the total
and I
penalty.
would say that you've already gotten an interest-free loan. One. And so, you know what I mean? You've already had this extended once without any additional interest, you know, being charged to you, and not that. And so again, I use the word interest because I just raised that it was an sort of an unenunciated benefit that you got from the initial overriding of the commission's clear request that this be done on a regular payment schedule. So you were able to get that one bite of the apple, and now you're asking for a second bite of the apple officially. And so I think that Commissioner Benedon's, it's sort of a 10%. So if you put that over the amount of time, I bet that the actual number is probably within a fairly, you know, reasonable level. But I don't know. I'll ask. I'm not uncomfortable with an additional $10,000 that will be split in $2,500 increments over the course of the next 4 months. So any commissioners, any other questions or comments? And I appreciate you advocating for your client. But again, as I stated before, the allegations against this client are extremely serious. They made millions and cornered 25% of the market. Now, again, you have not agreed to those facts. So I don't know, you know, I don't know how much they acknowledge that. But what I've heard is that this company made millions. This company put potentially other companies out of business by competing in a way that our investigations and enforcement staff said was unfair. So this, you know, anyway, I'll leave it. Commissioner Roy, do you want to reframe a motion? Do you want to?
Madam Chair, if I may, and
please.
I believe I just put in the chat what I believe the intent is, and then took into account Commissioner Roy's schedule, what a 10% surcharge would look like to the CFAO's point for 110,000 broken into 4 payments, which was one of the options. I can do the math on 3 if you'd prefer, for the dates that Commissioner Roy had calculated earlier, with a final payment due on April 11th, 26.
Okay. Are my fellow Commissioner Stebbins?
I think Commissioner Benedon may have brought this point up, but maybe not. Do we want to have any language which suggests the $10,000 surcharge goes away if they pay in full prior to the final date of April 11th?
And we're going to have to make it April 10th, not April 11th.
Oh, holiday?
It's a Saturday. The 11th is a Saturday.
Oh,
I'll note.
I
to the
have
board
made that
each of
change.
each of these dates are actually Saturdays, so just bringing that to the board's attention.
Okay.
28th of February is a Saturday, as is March 14th and March 28th.
Okay.
I will move them all.
All right. So, so I'm missing what you're saying. So well, the penalty goes away if they pay everything today. You know what I mean? I mean, and the problem is if we're now going to start doing calculations in this week and next week, I think we're starting to go ump ourselves, and I just don't want to, I just want to make this as clear and as understandable as possible, because we are, as I said, what happened in December was unprecedented. So we are now setting clear precedent in terms of directing what our staff does and what licensees can expect. And I thank Tim and Jake last week for, you know, talking about putting a new framework together on fines and making them more regularized. So this is less, I won't say less judgment, but that we have something regular that licensees can understand. So I get a little bit worried about erasing that, and then we're going to have to go back and do math again. Because I don't think that we as commissioners should be walking away leaving something like this. Either we're going to do it, and again, this is just my position. If other people want to argue against it, but I'm not sure if I understand. So they can get till April 5th and then pay it early and then get the money back, or not have I don't know what you mean, Commissioner Stebbins, if you could just clarify
Sure.
that.
Sure. And obviously there needs to be an agreement from, I mean, this is our new offer within the stipulated agreement that we hope the licensee would agree to. But I would also say, and let me just kind of reword it, thinking it through. If they pay the full 200, if they go back and decide they can pay the full $200,000 today and be done with it, I want to give them that liberty to do that.
That's fine. But what I want to make sure is, because again, I read this last statement, they could have lost their license by failing to comply with the original timeline. And they have not complied with the original timeline. And this has not been the will of the commission. So if they pay everything today, they're not going to pay the extra 10 grand. That's what you're saying? Okay.
We want to make that
Okay.
clear. I mean, obviously the licensee needs to understand this is the new part of the agreement. I'm assuming they also need to sign it.
Yeah. One of the things I want to make sure, and I don't know how to word this, but just having rewritten my will and putting language in that if you dispute this, you don't get anything in the will. Okay. And I don't want this to be negotiated anymore. Okay. This should never been negotiated in the first place. This is it. And so I'm just hoping that Attorney Glissman understands it's either get the 200 in and this is the alternative, but there's no negotiation here. Okay. Commissioner Roy?
I did put language in the chat to that effect, Madam Chair.
Oh, thank you. Okay. All right. So any further, Attorney Glissman?
I believe it enforcement.
Oh, who,
Either. Go ahead, Attorney Gooden.
Thank you, Dan. Madam Chair, I just wanted to note as well that the stipulated agreement does include language. I'm referring specifically here to paragraph 81. But the respondent has also waived certain rights to appeal the actual order too. So just wanted to flag that for you all's consideration. That is already contained in the agreement. Not to speak to the language suggested by Commissioner Roy, but just wanted to offer that for kind of your consideration as well.
okay. Attorney Glissman,
Oh, wait,
Commissioner
Madam
Roy?
Chair, just before, E.C. Gooden, could you read 81 into the record so everybody understands what clause 81? I'm reading it now, but if you could read it in its entirety, that would be helpful.
Yeah, of course, Madam Chair.
Please, thank you.
So paragraph 81 states, respondent further understands and knowingly and voluntarily waives the following rights. A, the right to proceed with an adjudicatory proceeding. B, the right to subpoena and cross-examine witnesses, present evidence, and testify on respondent's own behalf at that adjudicatory proceeding. And C, the right to appeal this order.
Thank you.
Attorney Glissman, you understand that, right? Okay.
Absolutely, and thank you, Madam Chair. And I'll just confirm for the record, and while we're here, that I have confirmed with my client that they're appreciative, and we would accept the revised terms for the 4 payments of 25%, including the additional $10,000 surcharge. So thank you all again for your consideration today.
Okay, thank you. All right, so Commissioner Roy, as we always, leave it to you to put together the legalese for our motions, and we appreciate our favorite non-attorney helping us frame this. So do you want to read what we have here?
I'd like a 3-minute break to just rework this motion language a little bit, please.
Okay, all right, so I'll entertain a motion. All those in favor say aye. Opposed, no.
Aye.
We will break for 3
Thank you.
minutes.
I'll be quick.
Okay.
I'll try to be quick. Thank you.
Okay, we are back in session. Commissioner Roy,
Yep. Would you like me to read it, Madam Chair?
please, please.
Okay, and I'm going to respectfully ask the staff to look it over, make sure that there's no omissions or the dates are okay, no Saturdays. So after I read it, just want to double check all of that.
Hold on,
Motion to
let's
revise-
specifically, let's give our general counsel, you read it and give our general counsel the opportunity to review this for content.
Okay, so we want me to read it now, Madam Chair?
Please, thank you.
Okay. Motion to revise the final and third payment schedule under the stipulated agreement duly executed on August 14th, 2025, and further amended on December 11th, 2025 between Assured Testing Laboratories LLC and the Massachusetts Cannabis Control Commission by increasing the third and final payment to $110,000 and restructuring the due dates as follows. February 27, 2026. 25% of 110,000 due, which is 27,500. March 13th, 2026, 25% of 110,000 due, 27,500. March 27th, 2026, 25% of 110,000 due, 27,500. April 10th, 2026, 25% of 110,000 due, 27,500 final payment. No further extensions of any payment due dates under this agreement shall be granted.
General counsel, are you satisfied that this language meets the needs of the commission and properly reflects what our intent here is?
Thank you, Madam Chair. I can state that it appears to reflect the intent of the board. The board will obviously vote to approve that, to indicate their intent, but as written, I think this reflects the conversation that you've had.
Thank you. All right, Commissioner Roy.
Should I add final order and stipulated agreement? EC Gooden or General Counsel, should I edit it and add final
Tim,
order?
Tim, does she, I mean, this agreement we're referencing, I mean, do we need to say final? Does she need to add that language?
Madam Chair, the document is the final order and stipulated agreement. I would defer to General Counsel in terms of the specific motion language. My impression is that this effectively identifies the document that you are seeking to amend. So including just stipulated agreement, I think is fine. And just as one other note in terms of the process of following this, similar to with the previous amendment, I'll follow up noting the amendment, which just requesting perhaps some leeway to make certain to format this in a way that will still be consistent with the formatting of the original document. So I would be able to amend that specific paragraph, the payment dates, and also note that there will be no further extensions of any payment.
But ministerial, we will.
Oh yes, formatting.
No, but I'm just saying. I mean, I'm not trying to be a dope here, but I guess I am. But understanding what the understanding of what ministerial changes are, that it's consistent, and it's not minor major. It's ministerial. So do we need to add that language? And so where would that be? And then so if you can enunciate that, and then Commissioner Roy can make the motion as offered by EC Gooden, I think that's how we will do this appropriately. But do we have to add that, allow you to format it, or ministerial, or do we need to say that in this motion?
Madam Chair, I think the Commissioner Roy just added one sentence to note subject to any ministerial edits by Enforcement Council. I definitely take the direction of the board and understand the conversation thus far too. Just as a reference point too, my intent would be to format the board's intent and the amendment to the stipulated agreement in a manner that is substantially similar to the last amendment that was issued via letter to Assured on December 19th and contained on our website too. So I would just want to make sure that I'm structuring it in a way that amends the stipulated agreement by striking the existing paragraph and revising it in accordance with the board's motion here.
Okay, all right. Commissioner Roy, would you like to make that motion?
I have a suggestion to Enforcement Council through the chair. When you send out that letter, could you please put the proviso, ratification proviso that's in the original final order and stipulated agreement under the executive director's signature? There's a ratification proviso, but it was not in the amended one because we did not ratify that. So could you please put that language back in?
That's on page 14. You see that, Tim?
Yes, Madam Chair.
Please, thank you.
Happy to include reference to the ratification and the vote of the board within that letter as well.
Yeah, so
Thank you so
ratified
much.
by vote of
Appreciate it.
3. Yeah, all right, so it'll
whatever-
be hopefully
whatever we have
4. Yeah,
today,
hopefully we'll
whoever
get 4. Yeah, we got 4. Ugh. So
Hopefully.
anyway, can't count. Yep, okay. All right, so Commissioner, would you like to make that motion?
Should I read the bottom paragraph just because I
So-
added language for the public
Yes,
to
thank you.
hear? Okay, so basically it's the same motion language through the dates, and the bottom reads, no further extensions of any payment due dates under this agreement shall be granted, subject to any ministerial edits by Enforcement Council. Thank you, Madam Chair.
So that will be your, that's your motion. Do I hear a second, Commissioner Benedon?
Second.
All right, having been moved and seconded, I will call the roll. Commissioner Benedon,
Aye.
Commissioner Roy,
Aye.
Commissioner Stebbins.
Aye.
Chair votes aye. It passes unanimously 4-0. Thank you very much. All right, now moving on to Commissioner Benedon, because she is an open meeting law expert, we are going to be doing this in 2 parts. We're going to raise the conversation here about Commissioner Benedon's thoughts about open meeting law and release of executive session minutes policy. We will not vote on that today. We will vote on that on Thursday, I believe. So anyway, Commissioner Benedon, I'll turn this over to you based on the work that you have done looking at our policy and how we need to update and improve that.
Thank you very much. So we have discussed this a little bit at the last couple of meetings, a little bit more in depth at the last meeting. So I'll keep today very brief, but this arose from discussions that seem to have been arising almost from the beginning of my time on the commission regarding our practice with regard to executive session minutes, the creation of the executive session minutes, the process for approval, the process and the timing and responsibility for doing the periodic review of executive session minutes, as well as the decision about who makes the ultimate decision when executive session minutes are appropriate to be released to the public. And although we had some practices with regard to this, and it was my own opinion that the practices that we had in place were compliant with the open meeting law, there was not a consistent written policy. We have had periods of time when there have been frequent executive sessions and then periods of time where there had not been any for a while. And so I thought it was simply good governance to have a written policy with regard to how we will handle executive session minutes going forward. To put a policy together, I didn't just want to put something together that is compliant with the open meeting law, that of course is necessary, but also to be thoughtful as to what would serve our commission, what would be good governance, what would provide for appropriate separation of responsibilities and transparency. And so, as I mentioned at our public meeting 2 weeks ago, I reached out and spoke with a number of general counsels and other individuals who work for other state boards and commissions just to get a sense of the range of approaches for how other boards and commissions handle their executive session minutes. And I used that input that I received to propose a policy. And so I am going to share that now in the chat. And the reason we're doing it this way, and I realize it might be kind of out of an abundance of caution to avoid violating the open meeting law, is simply that a policy that I drafted arguably contains my own opinions on the matter. and so should not be shared with a quorum of other commissioners outside of a meeting. So that's why I'm sharing the policy today. And then everybody will have an opportunity to review it, and we will have more in-depth discussion at our meeting on Thursday, and it is on the agenda for a more robust discussion. So I have just dropped that policy in the chat, and that's all for me.
So this is an opportunity for us to share this in public meeting, and we then will be absorbing this and voting on this hopefully on next Thursday. Commissioner Roy?
Through the chair to Commissioner Benedon. Thank you so much. I think this is long overdue. Like you said, even though we had practices in place, we really didn't have a concrete policy. So I thank you for taking this initiative on. I look forward to doing a deep dive into this, and just so I have a full understanding with executive session minutes, it's not stenography, so to speak. Is it more of a narrative, or how would you describe the goal of executive session minutes?
I would say that the goal of the executive session minutes is to create an accurate summary of the discussions that took place in executive session. It's not a stenographer, it's not a transcript, but a discussion that provides enough detail so that if somebody were to want to look at the minutes down the road, somebody who wasn't at the meeting, there would be enough discussion and enough substance in the minutes so that somebody could have a general sense of not only any decisions that were reached, but how the discussion unfolded that led to reaching that decision. So not every detail, not every remark, but the purpose really is to have a sense of what the decision was and how we arrived at that decision making.
Okay, thank you. Any other questions? And again, I echo Commissioner Ray, because this is something that, and we've had conversations about this, about, you know, we have delayed making a lot of these minutes public, and frankly, we don't really, I don't even know where to find them. I mean, I don't know if I've ever seen executive session minutes, or I guess we've approved them, but I don't know if I've ever had an opportunity to do that. So I appreciate your work on this, because I think it's important work. Commissioner Roy?
Having not read the document, does the proposed policy touch on the threshold for redactions?
It does not address the threshold. It references the legal standards to be used,
Okay.
but doesn't. So I suppose you could say that it incorporates those standards, but it does not spell them out.
And just to remind people, you know, this is also in electronic age. Obviously, we still have to do minutes for public meeting that are not held in executive session, but all of those are videotaped. I don't know if we've ever discussed this, but is it appropriate? We did videotape a series of executive sessions. Is it appropriate, if we want to have that kind of a faithful record, to videotape executive sessions? What would be the preclusion for us doing something like that?
Madam Chair, if you're asking me whether there is any legal prohibition on videotaping them, I do not believe that there is. I think that is more of a discussion of policy for the commission. Okay,
that might be something we want to, because again, this is also, you know, one of the things I've seen in terms of accuracy of memory, and because it takes so long, you know, we have notes, I guess we have minutes, but you know, when it goes a year, 2 years, or even 3 years after an executive session happened, and you may not have all the original participants in that meeting. And this is one of the things, is that we have to vote on minutes as commissioners, whether we know or remember. And I remember one person, you know, stating, well, you know, Commissioner Roy, you take great notes, so you should know anyway. But the fact is, you know, when you're participating in an executive session, you don't want to be furiously taking notes as you're debating and going back and forth. And sometimes it's heated and, sometimes it's, difficult conversations, and you don't want to have to be doing something that's a check-in. With all due respect to Vanya, all our great paralegals, have done a great job of doing this for us. But this may also be something that we want to consider, because I don't know about you, I'm getting old. I can't remember what I did last week, never mind a meeting I had 3 years ago. And especially because it has taken so long in many instances to release executive session minutes, that's something that we might want to consider. Again, we do it with public meetings, and as we know, executive session is a public meeting. It just stays behind the screen until that purpose is extinguished. So anyway, Commissioner Benedon?
Yes, and one thing I'll note, although of course we can discuss further on Thursday, is that in some respects, what I put into the policy is intended to go beyond the requirements of the open meeting law in terms of accuracy and transparency. I can say that the Attorney General's current guidance regarding executive session minutes, and this follows a court ruling about 2 years ago, is that there is not a requirement for a public body such as our commission to formally vote to approve executive session minutes the way there is for open session. But I think that is good practice, and that it should be done very quickly after a meeting, exactly for the reasons that you've just stated, Madam Chair, that notes can get lost, employees can leave, memories can fade. And so one thing that I did think was very important to put in the policy is a requirement that our legal team will draft the minutes and that we as commissioners will approve the minutes. And I suggested in the draft policy a timeline for doing so that is quite quick, because even if the minutes are not being approved for public release, I think it's important that there is agreement that what we have is a set of minutes, even if it's being held internally, that is accurate. So I do think that is very important, and that's it.
And it's interesting, given that public meetings are public and the public can watch, right? Yet, you know what I mean? In terms of executive session minutes, it's behind those closed doors, and there's a different, lesser standard for that, which I find fascinating. Again, nothing to comment on, but I just find that that's interesting, that it's not a requirement to approve executive session minutes, but we want to go beyond what the basic laws are, because we want to be more transparent. But thank you again for your work. Commissioner Roy, you had your hand up.
Yeah, again, thank you so much, Commissioner Benedon. And to the chair's point, all of our public meetings, this meeting will be memorialized on YouTube. And anybody can go back and watch it, and hear what we said verbatim. And really, there's not that luxury with executive session unless we vote to release videotapes. So I don't know if that's something we want to bake into this proposal, but just flagging that. And also, Commissioner Benedon, I look forward to reading this and voting on this. And if you could have motion language ready for Thursday to accept something like that, would be very helpful. Thank you.
Yeah, thank you. And again, I appreciate this. And remember, this meeting originally was solely going to focus on the assured. This was an not emergency, but a last minute meeting that we added. So this is just a launching point. We get to talk about this, but obviously we have until Thursday because we had this bonus meeting this week that we didn't plan on. So Commissioner Roy?
So on the first one on the agenda, Madam Chair, I think it's worthy of a conversation. If you want to table it, I would like to revisit it. I've questioned it many times when I have been recused. That is it okay for me to sub-delegate? I get queasy every time. And so I'd like to know the legal underpinnings for sub-delegating when I have formally recused. And also, if all of us could read up, including the general counsel, on rules of necessity, I think that would be more appropriate. If we thought about a policy around rules of necessity, if we're not at, if we only have 3 and one of us is recused, that perhaps we invoke rules of necessity and we have a procedure and policy around that. So just want to flag that. And the legal underpinnings for how we were able to, because we could be assessed, if we're not doing it right, we can be assessed a fine of $10,000 as commissioners if we're not, if there's a conflict and we're not handling this appropriately. And that's us as commissioners who could be personally liable. So I want to make sure that we're handling this according to state ethics laws and where we have the right policy in place. And I'm not 100% sure that we have been. So I look forward to this discussion at a later time.
So one of the questions I have, okay, is all right, so we have a memo, and this is a question for our general counsel. We have a memo regarding delegation, and again, I read the memo and I'm a little uncomfortable because I'm not comfortable with some of the responses in here, but it's stated that it's privileged and confidential. So how do we discuss this memo if you have labeled it privileged and confidential? Do we need to waive that privilege now, or can we not talk about your memo?
Thank you, Madam Chair. The memo contains legal advice to the commission, and as such, it is protected by attorney-client privilege. And in order to waive it, the board would have to affirmatively vote to waive privilege.
So does every memo or piece of advice that we get from legal counsel amount to something that is privileged and confidential? We're getting stuff from enforcement counsel. As a matter of fact, I got an email when I was asking about whether or not I should take a meeting ex parte with Assured. And again, you've written an email telling commissioners not to receive information from Assured. So is every single communication which provides legal advice, is all of that privileged? Or as a public entity, is this something that should be public?
Well, the rules of privilege do not differ because we are an organization. Attorney-client privilege is a long-established concept that applies in the context of an attorney-client relationship, whether it's in an organization or an individual. So I guess I'll put it that way.
Can you get some legal underpinning for that? Because I don't know if that's accurate.
I have issued a legal opinion.
You what?
I'm sorry. Please continue.
Well, we're a public agency, and there are opinions that we receive constantly from attorneys, whether it's Attorney Gooden, who suggested that I not take a meeting, and you have sent out emails suggesting people not take meetings. So is every communication from legal that provides an opinion confidential? So like if someone, and I know we're having problems with our public records request. So does that mean that
just to correct the record, just if I may, there is no problem with our public records requests. You've now stated that several times. I need to clarify the record on that. I just keep getting
emails from multiple people who are
concerned that if you're getting emails, Chair, I'm a little concerned that you are getting emails and these record requests are not being filed in the appropriate manner. So
every time I get it, if I can interrupt, if I can, every time I get an email from someone complaining that we have missed statutory deadlines for responding to public records requests, I forward that to the executive director, and I probably assume he's going to forward that to you. So if they're coming to me, I can't stop people from complaining.
Well, let me just say that I'm not aware of any public records request that we have missed. We have missed a deadline on. If you're getting emails about public records requests, it does raise the question to me that perhaps they haven't been filed properly using the proper process. So to the extent that you are getting emails, I would suggest that you should refer them to me.
Again, I refer them to the executive director. And I'm assuming, again, generally that's what I do. When I get complaints about employee performance or lack thereof, I share it with the executive director because that's his job to manage how work is getting done and how to deal with public issues. So again, that's my process, and I'm happy to work with you in the future. Commissioner Roy.
I'd like to flag that for a future meeting, a public records request, and talk about that process, because when I was secretary, I would get a report on all the PRRs who requested them and what the topic was and how many we fielded. So I don't think that is confidential. That should be withheld from commissioners. I think that's something that should be shared with all the commission, especially the secretary. So maybe we can put that on the agenda, talk about the current process or lack thereof process and practice, and perhaps formulate a process around PRRs as well.
Okay, that makes sense. So anyway, so do I need to entertain a motion to lift the privilege on the memo that you've sent us so that we can have a conversation based on the advice that you've given to us? All right, I will entertain a motion to lift the privilege so that we can actually use this memo regarding delegation of powers to approve licensees. Do we want to do that? I don't know, Commissioner Roy. I don't know. What are your thoughts? Or Commissioner Bennett, you're the Commissioner Roy. I mean, again,
Chair,
go ahead.
I'd like 2 minutes a break. First of all, I do need a break. But secondly, I'd like to look over that memo one more time before.
How about this? All right, then let's then you know what? I'll withdraw the question. It may limit our ability to have a conversation on Thursday. So anyway, why don't we can table this, because I think it's also getting close to time for lunch. I never anticipated this meeting was going to go as long as it has. And again, my apologies, but I think
the executive director.
Yeah, no, go ahead, executive director.
I was just going to know, Madam Chair, that we do have this on the agenda for Thursday, similar to Commissioner Benedon delivering the policy for discussion on Thursday.
Right.
We have delegations on there, so maybe we could take that up at that time.
Yes, but again, I don't know if we're going to be able to take it up because we will not be able to have this legal opinion. So anyway, I just want, again, Commissioner Roy.
Madam Chair, respectfully, maybe if you have motion language prepared for Thursday to lift the privilege, I think if we all are inclined, or 3 of us are inclined, I think it happens instantly. So if we vote to decide that it makes sense, 3 of us, to lift privilege, I think, and correct me if I'm wrong, any of the attorneys, that we could begin those conversations in earnest once we, so if Thursday, if you have motion language prepared and 3 of us are inclined, I think the privilege lifts immediately and we would be able to tackle it at that point.
Okay, and I also would ask the general counsel to do some research on the issue of the rules of necessity, because I think that will provide us with a better opportunity to avoid what I think is multiple inappropriate delegations of authority in mid-meeting. So if you could do some research on that before, again, I don't know if we can. Okay, all right, Commissioner Roy.
Yeah, and I think this is a really important conversation, because I have recused myself properly, voted to subdelegate, and then heard, why is she voting on this? How can she even vote on this when she's recused? And de facto, I am voting to subdelegate. So that's where I get a little queasy inside, because I have heard an earful as to why I'm still participating in a matter when participation in a matter is defined broadly and loosely, and technically that's still participating in a matter. So this is why this conversation is very important.
Okay, all right, so Executive Director, last point, and then I will entertain a motion to recess until next Thursday. Go ahead.
Thank you, Madam Chair. I believe Commissioner Roy had made that point before, and I think that can be discussed on Thursday, so it can wait till Thursday.
Okay, all right, thank you. Commissioner Stebbins, I'll entertain a motion to adjourn until, is it, hold on, 10 or 10, till next Thursday, the 12th. Oh, here it is. Oh, there it is. Okay, next Thursday, the 12th at 10 a.m. I'll entertain that motion, Commissioner Stebbins.
So moved.
Do I hear a second, Commissioner Benedon? Oops.
Second.
Having been moved and seconded, I will call the roll. Commissioner Benedon.
Aye.
Commissioner Roy.
I'm going to say aye, but are we in person? It's hybrid, but are we? Yes. Okay. Aye.
Yes. Yes. Commissioner Stebbins.
Aye.
Chair votes aye. We unanimously adjourn until February 12th. Most of us will be in person, but it is the opportunity to attend hybrid at 10 a.m. Thank you.
Thank you.